All right, we are on the record in cause number F038930-B. And sir, are you Luther Garner? Good morning, Mr. Garner. And we've got Mr. Udishin, Ms. Gilbert, Mr. Coleman, and Ms. Shield here present. Before we get started, this is obviously the hearing with regard to the Court of Criminal Appeals request, I guess, order that I make certain findings based on potential new evidence or scientific evidence that's different with regard to what was commonly referred to as shaken baby syndrome. Before we get started, obviously, I think there's a few housekeeping matters that we need to take care of before we get started. I've given everybody kind of a certain amount of time. We'll work around times and obviously make sure it's fair for everyone with regard to witnesses. The initial, I think the initial thing I want to talk about first this morning has to do with the affidavits that have been filed by both parties with regard to their admissibility and the ability of each other's the sides to question and have appropriate hearings with regard to any of those affidavits and the expert testimony, and whether or not I would in a hearing consider that they're experts. Mr. Coleman has filed a motion asking to where is it? Let's see. Objection to affidavits, in particular of Dale Baslow, the affidavit of Chris Van E. Let me make sure I've got all this. And particularly a motion to strike and withdraw the affidavits and the studies filed by the applicant based on the reading that he has of Article 1107 with regard to affidavits. And I know the other day when we visited at a pre-conference that I felt like it was unusual to be able to just present affidavits without any sort of kind of gatekeeping or dauber hearing or whatever hearings that typically have when someone would testify as a quote expert. And so it appears to me, and I guess Mr. Udishin and Ms. Gilbert, if you guys want to explain how what I'm reading and what Mr. Coleman's position is, and I tend to, unless you can show me otherwise, and that if after hearing I need more information, then at that time I can request whatever, more testimony, affidavits, interrogatories, forensic testing. I can do whatever after a hearing and say, you know what, I don't have enough information. I need these things. But to be able to just put an affidavit in the record that's going to get sent to the Court of Criminal Appeals, that for either side, that the other side does not have the ability to question the expert background, what they all of the things that we'll get, I'm sure, today with the people in person. So response to that?
Your Honor, 1107, I think that Mr. Coleman is wrong on the interpretation of when the question about affidavits comes in. Under 1107, once the court designates issues and decides the issues to be resolved, and of course, the issues to be resolved are the issues that the Court of Criminal Appeals has designated. So once issues are designated, then the trial court decides how to resolve those issues. And under 1107, it sets out various ways to resolve the issues: a hearing, affidavits, interrogatories, personal recollection of the court. So affidavits are in the same portion of 1107 as a hearing. So the typical way on a typical 1107 writ, as the court, I know the court knows, it's more often resolved on affidavits alone, and holding a hearing is not the normal way or the usual way 1107 writs are resolved. So affidavits
But that
are,
would typically be like an ineffective assistance of counsel claim where we would ask for an affidavit from the counsel that handled the case. Or I, for instance, asked for an affidavit from TDC with regard to time credit or some issues that were from TDC. Expert affidavits or alleged expert affidavits without that finding, I think fall under, I mean, a different scenario in my opinion. And I think they're not just to file them without my request of them, I think is probably improper. And I'm not saying I don't want to see them. I think what the proper route would be is to get through the hearing with whatever live testimony there is, get through the second part that we know we're going to have with Dr. Is it Avasan?
Ophoven, you're
Ophoven, just renamed her, with Dr. Ophoven. And then after that, if I feel like I need more information, then what I think would be appropriate is to say, okay, we intend or we have this information from this person, whether it be a doctor or a lawyer or whatever it is that we think could help with this issue. And you could potentially, we have at the end of the hearing, a proffer that you would like to have this information. And then I make the decision whether or not I feel like it would help me with my decision. But just to have it as part of the record and for which would then mean that I would really be required to take it all into consideration because obviously it's going up. I don't think that's proper at this time.
Well, and Your Honor, can I just add
Sure.
one more thing? Of course, we would rather present all of these witnesses in person, but because of the time constraints the courts put on hearing, on the evidentiary hearing in this case, we don't have time to present all of the evidence in person. If the state objects to hearing evidence by way of affidavit, which I believe is permissible, but if the state objects to it and the court's not inclined to allow it, then we would request the court to give us some additional days to call the witnesses in person, because a day and a half that we've been given to present our case is not enough time for us to present Dr. Monson, Dr. Baslow, Keith Finley, any of the other evidence that we presented by affidavit. So we would request additional time.
And I would think that would be a reasonable request. And so let's do this. Why don't what I'm going to do right now, just so that the record's clear, and then at a later time, if I allow the affidavits in, we can put them in at that time. So for right now, I'm going to grant the state's motion to strike and withdraw those affidavits from the record. And I also, I know Mr. Coleman, you have also filed affidavits. And so I'm going to, at this point, strike. I want all affidavits that have been filed in the case are stricken. They're going to be withdrawn from the record at this time.
That was my next question, Judge, about the housekeeping, because they're on file with the clerk's office. And per 1107, if they're on file at the conclusion of this hearing, they all go up.
They're not going to go up unless at a later time I say, okay, this is the time frame. Obviously, we're going to, after this week, we'll get Mr. Florence is here in the back for everyone. Mr. Florence will obviously help us get I think it'll help to get more time with the Court of Criminal Appeals, since we've started the hearing that there was a medical emergency with one of the witnesses. I don't foresee that being an issue. And at the end of what I hear this week, may help determine, instead of just having that doctor come back, allowing some additional time for some of the ones that you had, and we'll obviously coordinate that. I may at that time have enough information to say, you know what, I am going to look at this affidavit or that affidavit, and you guys can proffer what you want me to look at, and I can make that decision at that time also.
And Your Honor, if I could just add one thing, I think Mr. Coleman's correct that since the affidavits have been filed when the clerk sends the record, they are required to send everything that's been filed. I understand the court is saying you're not going to consider them at this point, but nevertheless, I think the proper procedure is going to be that they need to go to the Court of Criminal Appeals. And then later, if you make a final decision, the court makes a final decision that you're not going to consider them, they are required to be in front of the Court of Criminal Appeals for them to decide if they're going to consider them, because this court's making a recommendation, but the Court of Criminal Appeals is making a de novo ruling. And so they're entitled and required under 1107 to see everything that was filed by both sides in this case.
And I object to that, Judge, because to send it up is essentially giving the Court of Criminal Appeals an opportunity to consider something that this court did not consider in making its findings of fact and conclusion of law.
And of course, the Court of Criminal Appeals can consider whatever they want to. They don't have to consider.
Well, I feel like
anything.
it's a way around.
Yes.
It's just a way around to get whatever either of you want up to the Court of Criminal Appeals. I will do some more research on that. As of right now, I'm striking them. If there is something more legally that I can do to make sure that they, unless I admit them do or don't go, we'll look into that. Mr. Florence will take a look at that for me, and then we'll get that figured out. But as of now, I haven't looked at any of them. I've got enough other stuff that you guys have sent me to look at before that. And so I actually have not begun any type of review of any of those affidavits anyway. So that's going to come during and after.
And just for the record, we object to the striking of the affidavits. We don't think there's a procedure to strike something from the record. I would ask the court segregate it from the record, seal it if you want to, but nevertheless, it needs to go to the court.
We'll figure out the proper way to get that done. I obviously I don't want them to send something back and say you need to send it up. So whatever we need to do to make the record clear at the end of the hearing, once I have decided I am or I am not going to look at which ones, any or all or some of them, then at that point we can work on exactly how to, okay, I reviewed this one. They need to know I reviewed this one. I didn't these and why and how to do all of that. So we'll just kind of hold for now. I'm not going to take a look at any of them. And then at the end, we'll figure all of that out to make sure that the record goes up the proper way that I guess I at the end feel like it should.
Okay, and just one final objection for the record, Your Honor. I do object to the court's conclusion at this point not to review them and not to consider them, because I think that is contrary to 1107. I don't mean to quibble with the court about that.
Yeah,
I want
no,
that on the record that we object to that.
And I'm not saying I'm not going to, because I think at some point, if I'm going to, there will at least need to be a proffer of what they are. And I have so far read every single thing. I just want to hear what you guys have to present first, so that I have a general understanding of where you're coming from. I'm hoping that you didn't intend for me to start with my understanding from affidavits. And so I would think that the two in-person witnesses that you've selected would be for a good purpose. And so I'm going to listen to all of that, obviously take everything that I need to into consideration.
Thank you, Your Honor.
Okay. So before then we get started with the actual hearing and witnesses, is there anything else?
Your Honor, I filed a motion to exclude an expert witness from the rule. Cited some authority in my motion that allows me to.
I think
to
Mr.
do that.
Udishin has already emailed that he didn't have an issue with that. Is that correct?
I agree, and I would like our expert to also be excluded from the rule, and I think we're in agreement on that.
Absolutely.
If he designates who that expert is, I'm not exactly sure.
I just said Dr. Galasnik. I would ask him to be excused in the same way Dr. Edwards is
Sure.
excused.
Yes, absolutely.
Your Honor, I've also just a pro forma matter filed a motion for a running objection as to the admission of any medical testimony or evidence outside, it wasn't admitted at the underlying trial. I know the court's already ruled on that, but I just wanted to have that preserved on the record for a running objection as to any medical evidence or testimony that was not submitted or.
I think that's the whole purpose of this hearing, right? I mean, it's if there is any new medical or scientific evidence that, I mean,
New science, Judge.
it's, we'll read it again. The Court of Criminal Appeals, the trial court shall make findings of fact and conclusions of law as to whether applicants' allegations and previously unavailable medical and scientific evidence contradict the state's experts' trial testimony and whether this evidence would be admissible. And so I don't see how you can kind of separate the two of if there is new information, scientific or medical, that has to do with the case and specifically shaken baby syndrome. We are not getting into, I'm not going down into the weeds of anything other than the allegation and shaken baby syndrome. And that, I mean, that's where we're headed. So if we start going down another path, I'm not going to, I will myself, I'm going to limit what I need to hear. If we start going down a path that has nothing to do with the underlying facts of this case, I'm not going to go there. So
Yes,
guess
Judge, and
that-
I understand the court's position, and sounds like you're denying my motion for the running objection. I just want to.
you can have a running objection.
you.
Yeah, that's fine.
Okay. Your Honor, there's also the matter, I don't know if you want to check this up a little later on, the matter of the expert testimony of Keith Finley, that they've designated Keith Finley, as I understand, is an attorney, not a medical professional, and any opinion he's going to give will not be based on medical science. In fact, I don't know that he's even reviewed any records in this case. And I don't know.
Well,
if
that's an
it's up later.
affidavit. And so he's not, you're at this point, you don't intend him to come. That is one of the affidavits that's been submitted, correct?
That's right, Your Honor. We would ask him and want him to come if the court's
Sure.
not going to consider his affidavit.
So let's look again. I want to, well, I'm going to hold ruling on that. I did look at least because you had filed that, I looked at the CV and obviously he has some extensive, if nothing else, information and has done some extensive research and writing on the subject. I don't know that would limit him or not. So I'm not going to rule on that now. Again, I'm going to hold that. Once we get to the end, if I feel like I'm going to allow either the affidavits and or require them to come testify, then we'll talk about that at that time.
Just for the court's information, Judge, I've included it's a federal court opinion. Yeah, forgive me, I can't remember if it applied to their expert Chris Van E or one of the other experts, but in that federal court case, that judge struck or limited the testimony of a expert witness where it was medical in nature and they didn't have a medical background. And forgive me, I have that. It's attached to one of my.
I'll take a look at it at the appropriate time.
And I think that's kind of my objection to Finley is he's.
We'll get to it.
Okay, yes, ma'am. I filed an objection to the testimony of Dale Vaslow, Judge.
If they're not, so as of now, Mr. Coleman,
Yes,
my
ma'am.
understanding is it is only Dr.
Glasnick, and then
Today.
later today.
Today.
And then later.
So I don't want to take any more time with regard to at this time of the witnesses that they filed for affidavits. I'm going to listen to the actual evidence in person and then make a decision on whether or not I want to hear more and then can hear any objections about those.
This is not an affidavit objection so much as they did not designate Dale Vaslow as an expert witness, Judge. Only late last week did they amend their witness list, and I would submit to the court that by not following the court's scheduling order, by not designating Dale Vaslow as a witness timely, it is tantamount to trial by ambush to now try to bring this witness as an expert witness.
Your Honor, I think this is the subject that we discussed in our last couple of Zooms, is that we moved for continuance because of the late providing of the scans in this case. We needed experts that were experts in looking at scans, like a neuroradiologist, which is what Dr. Del Vaslo is. That's why we asked for a continuance, because it took us so long to get the scans, partially because the state opposed us getting them, which delayed it by a month or 6 weeks. And the whole point that we asked for a continuance on was that we were in the process of having the appropriate experts look at the scans, and they couldn't look at them before.
But
And
you
that's
knew
who
who those,
Dr. Vaslo is.
but you knew who those experts were if they were just waiting on the information. That's not a new expert. Again, I'm not going to rule on anything other than right now. Let's get started with the hearing. The experts that are here in person, let's get through that. And then at that point, we'll continue the hearing for at least the one doctor and potentially more if I make a finding that I'm not going to take a look at the affidavits, or I will on some and not on others. And we can work that out at the end of this week's hearing. Okay.
And could I just add one thing concerning Dr. Vaslo? We listed him as soon as we reached a point where we
Again,
knew we
y'all
were
are
going
arguing
to-
something that we're going to argue again in 2.5 days if we keep going. So I don't want to talk about anyone else other than who we've got here in person this week. We're wasting that time because I may or may not allow it. So let's get going with what we've got. Obviously I'm not making any rulings on any of that until we get through this part of it. Okay.
That I understand when we called Dr. Galaznik, we had made some objections at different points in these proceedings to the state challenging the new science holding of the Rourke case. And the state has gone forward and appears to be making that challenge. And since we're going first, we're going to be responding to that challenge in our testimony from Dr. Galaznik. Although I just want to make it clear, we're not intending to be waiving our argument that that's not really within the scope of this hearing. And so I would again ask the court to limit the scope of the hearing to where the state is not allowed to challenge the new science holdings. And if the court makes that ruling, then it cuts down on what we talked to Dr. Galaznik about. If the court's not making that ruling, then I will need to go ahead and talk to Dr. Galaznik about all the new science.
And Your Honor, the state, to be clear, is not challenging the Rourke case and what the Court of Criminal Appeals has previously ruled that it termed to be new science. What we want to do is provide the court the full information, all of the science, not just some of the science, but all the science, so that you have the complete background on
Sure.
on
And that you intend for your witnesses, that's what you're bringing.
yes.
Okay. So, I don't know if that helps.
So I guess
Let's just see where we get. How
the
about
court's
that?
just going to have to figure it out later. I understand.
Yes.
So we're ready to get started, John.
You guys are challenging my brain. All right. Anything else? I hate to ask that question before we get started.
Not from the state.
No, nothing else, John.
All right. Then at this time, Mr. Udishin, you may call your first witness.
We'll call Dr. John Galaznik. And do you question witnesses from the podium, Your Honor? Is that how you do it?
We do normally. I know you guys have a lot of information. The biggest issue is that it's hard for the court reporter to see around this way. So if y'all don't mind, it would
No,
be
that's
good.
fine.
It's a little easier.
Judge, would now be an appropriate time to offer some exhibits into evidence?
Sure.
Mayor French?
Yes. Let me do this. Good morning, sir.
Hi.
How are you? Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat. And if it's not already on, there's a little button on the left.
It's green.
It's green. Perfect. If
Hear me?
you'll, yes,
Yeah.
pull it down just a little bit.
Should we do it?
Uh-oh.
We're good. Sorry. Okay. These are for you, Judge.
And if you want for the record, if you'll just state what the numbers are, and then if all of it's been provided to
Yes, yes, Your Honor.
state's attorney.
Copies have been provided to state's attorney. These are 9 exhibits in total. 3 of them are media files.
Okay,
Yeah, Your Honor, at this time, state objects to applicants number 8 and number 9. Those are studies, appears to be case studies, for the reason that I put in my motion, that there needs to be the proper foundation. Foundation being that this expert is relying on these in making his assessment or providing his testimony, and that these are reliable. Until such time, the state objects.
to 8 and 9, and so
Yes.
there's no objection to 1 through 7.
No,
So 1 through 7 are admitted. Do you want, with regard to 8 and 9, to question Dr. Glasnick about those at this point, or Mr. Coleman take them on board, or whatever the easiest way to get that?
Charles.
It's the. And the. I think it's-
Atkinson. Okay, the Molina article will hold for Dr. Ross on nothing, so it's really just Atkinson. Your Honor, one of them will withdraw the Molina article, which we're not intending on that to be for this witness. That's
Okay,
later with-
which number is
what,
that?
you know, which.
Number 9.
Okay, if you'll come withdraw number 9 then, and then with regard to number 8.
Number 8 is an article, it's the Atkinson article, and I am going to be questioning him extensively about that in his testimony. I can do it now or do it later.
I don't think, let's not get into the extensive part
Okay.
now, but let's do that once you get to that part of your questioning. If you'll just lay a brief foundation that he has or has not relied on it, and that'll, I think, get us where we need to be with regard to it being.
Oh, that's fine. Dr.
Let me get this attached real quick.
Oh, yeah. Okay, perfect. Perfect. Yeah. All right. Good. Thank you. You make, go ahead.
Dr. Glasnick, you are familiar with an article called Childhood Falls with Occipital Impacts by Norrell, Atkinson, and others.
Right,
And is that an article you have studied extensively?
yes,
And is it something that you will be testifying about today?
yes,
And is it something that you rely upon in general in this area in reaching your opinions concerning the issues in shaken baby syndrome?
yes.
Your Honor, that's my short version.
Judge, if I can have a question or two on board hour, please. Good morning, Dr. Glasnick.
Morning, sir.
Where was this article published?
When?
Where was it?
I'd have to
published?
look where it was published, but it was published in 2018,
You don't
December
know,
2018.
you don't know.
If you
it's
show me at the
published.
very top of it, is it Journal of Neurosurgery or Trauma? I don't know.
Let me make sure I ask the question fully before you answer. Was it published in the American Academy of Pediatrics Journal or some journal or some publication? Where was it published, sir?
It was published in a peer-reviewed quality journal.
By the name of?
I don't remember the names of exactly where hundreds of articles were published.
Sure, well, that's like us not knowing the name of show it to them and see, I'm not gonna expect anyone to remember names and numbers of things because I don't, so we're not gonna go down that path, so let's.
Judge, I think that's the bare minimum for its authenticity and validity. Where was it published? And if it was published there, was it peer reviewed? And that's really all I'm getting at. That's
Sure.
been my questions.
If there is something, Dr. Glasnick, that would refresh your memory, you're welcome to take a look at it.
Looking at the article would help me refresh my memory. I don't know that I have a copy up here with me at the moment, but it was published.
Can I approach?
Please.
Pediatric Emergency Care, Volume 34, number 12, in December of 2018.
In pediatric emergency care, is that a publication or is that an organization?
That's a publication, peer-reviewed journal.
Okay, very good.
And the authors of that are from the Helper Society of the Child Abuse Pediatrics. So that is an article published by the child abuse community themselves, of articles that they themselves collected among themselves.
Judge, I was gonna break the narrative. I just asked him just a straight up question about what was.
Let me get all the information. There's not a jury here. I'm gonna get as much information as I feel like I need to, and I'll probably stop you guys before y'all object. Let me just, before we go any further, I guess I have a potential, my own question with regard to the title has to do on this one with the Atkinson that we're talking about, which is applicants 8. It's titled Childhood Falls with Occipital Impact. My question, I guess, is the relevance of an article that has anything to do with childhood falls, because the facts in the underlying case that we're here for, there was no testimony or allegations that it was a fall of any sort that could have led to the injury. And so I don't want to go down the fall path. We're not going to spend days talking about how far it is and if it's off a bed or whatever, because that has nothing to do with the underlying facts.
Your Honor, that I agree. That's right. The reason why this article is important is the state's experts in their affidavits, which I know the court's not considering now, but they've given us some heads up essentially that their position is there is no new science in the shaken baby syndrome area. So when they say there is no new science, we feel compelled to explain the entire breadth of new science, which includes short distance falls.
Yeah. We're not doing that.
Okay, well, that's fine, Judge.
Yeah, I don't think that is, I can sift through the fact that there has been, at least if nothing else, a shift in the science and the scientific methods that have been used to look at these cases. I'm not gonna say that there's not. I don't know that if there's some expert that can convince me otherwise. There's no doubt that there's been a shift. That's why we're here. So I don't need to go down that path and have that, I guess, full on education of all of it. I want it limited to the facts of this case, as best we can with what information, probably some basic information that I'm going to need because I'm not an expert in this, but going real far down the path of the whole background and specifically things having to do with falls. I think that is going to take up a lot of time that's probably not necessary.
I agree.
Okay.
Court's correct. We may, if they get into it, we may have to come back around on it on rebuttal, but I agree at this point.
Okay, perfect. And I would give you that opportunity. So let's do this for now. Is there anything, I will allow 8. I'm going to overrule the objection with regard to 8. I'll allow it in. Obviously the testimony and the amount of time that we give it, I think, will be probably less than some of the other things. Makes sense?
That makes sense, Judge. We can
Okay,
do that.
perfect. All right. So now we've got 1 through 8. And 9 has been withdrawn. Anything else?
Okay, then we're ready for the
All
witness.
right, let's do it.
Okay, sir, would you state your name, please?
John Gilbert Galaznik, Galaznik.
And you're a medical doctor, is that right?
Correct.
Would you tell the court your educational and professional background?
Yes, I graduated from the University of Texas in Austin in 1970 with a degree in zoology. I then attended medical school from 1970 through 1974 at the University of Texas Medical Branch in Galveston. And the last year of my medical school was entirely pediatrics. Then I did a straight pediatric residency at the University of Utah in Salt Lake City from 1974 through 1977. And at that point in time, we took part one of our board certification exam during our residency, which I took and passed. And then we were required to practice pediatrics for 2 years before taking part two of the board certification exam to complete our certification. So in 1977, I volunteered for service in the United States Air Force. From 1977 through 1980, I was one of the two base pediatricians at Ramstein Air Force Base in Germany. Busy outpatient, diaper changing, snotty nose, throat culturing, immunization giving practice, the on-site lab and X-ray. And in that setting, we were required to look at all imaging before the radiologist did the review. Not that I'm a radiologist, but it was part of what we had to do. In 1979, I took and passed part two of my board certification. So I am board certified in pediatrics. The young guys, after about 1990, are required to retake their boards every 10 years, but we old folk are grandfathered in. So I am board certified in pediatrics, but I'm an old folk. And so that's my educational background. In 1980, after completing my service in the United States Air Force, I had always wanted to practice college student health. That is really has much more to do with pediatrics than adult medicine. The kids are coming from their pediatrician. We are not treating diabetes and hypertension. We're treating cuts, sprain, bumps, bruises, and the college spectrum of diseases. And many of the physicians going into that area are pediatricians. So I consider it higher end, older pediatrics. So in 1980, I applied at every university in the southern half of the United States. Texas and A&M were not hiring, but Alabama was. So I took a job as a staff physician at the University of Alabama Student Health Service in Tuscaloosa, providing primary medical care to college students. We had on-site lab and X-ray. For the first 8 or 10 years, we had overnight infirmary type of care, but after that shut down, it was basically primary outpatient frontline pediatrics with on-site lab and X-ray. Again, showing and looking at all imaging before it was overread. Anything overwhelming, of course, meant to be emergency room straight across the street. And so that's my clinical practice at the university there. I did have a stint as acting director and acting chief of medical services during that period of time. But that was what I did at full time up through 2021.
So at some point, I think maybe while you were still working at the University of Alabama, you became interested in infant head injury cases.
Correct.
Can you tell the court how you became interested in that area?
Yes, in 1999, I got my jury summons for a capital murder case involving the death of a child. I, of course, did everything I could to get off that jury, but I was not excluded. And that was a fairly emotional experience. It was a death penalty case. And after my involvement there, I decided this was an area that interested me and I might have something to offer. So in 2001, I had 25 years of credited service in the University of Alabama retirement system, which allowed me to retire from full-time employment, continue to work there part-time contractual basis, covering weekends and when people out sick during the term. But to have income while I pursued my interest in the area, physical injury of infants and small children. No interest in sexual abuse or neglect issues. It's clearly the mechanical mechanisms of injury of infants and small children.
Okay, so once you develop this interest in childhood or infant head injury cases, how did you get involved in that area?
Well, of course, first you start by concentrating on the literature, and reading the literature, then attending meetings, and then associating with fellow physicians interested in pursuit of the same area. So since 2003, 2004, I interact almost on a daily basis with physicians from around the world, neurosurgeons, pathologists, radiologists, neurologists, who also have an interest in this area. Also, I did have the opportunity to go into a biomechanical laboratory and participate in hands-on biomechanical experimentation with a biomechanical person and in studying the shaking or the rotational acceleration deceleration mechanism of injury. And most of this kind of research usually involves a biomechanic expert hooking up with a pediatrician and a neurosurgeon to do this kind of research. They're not doing it isolated. It's usually other Carol Jenny, Cindy Christian, child abuse doctors are going into the laboratories.
But let me ask you, in addition to the studying of the literature and your involvement in research projects, have you, since you began to become involved in this, have you been available for lawyers to hire you to review child head injury cases?
Yes, I started reviewing cases and not testifying, just consulting initially. Then I got into testifying.
How many times, do you have any idea how many cases you've reviewed?
I stopped counting at 400. Of course, it's been 20 years. And I stopped counting testimonies about 150. And that was some time ago. I've given expert testimony in 34 states, in Canada, in New Zealand, and I've reviewed a number of cases for the United States military. And I've testified in Stuttgart, Germany, Kaiserslautern, Germany, Fort Hood, Texas, and Fort Lewis, Washington.
Okay, and you testified as an expert in the Rourke case in Dallas, is that right? Okay, so I'm going to get back to that in a minute. Can you tell us how you got involved in the Garner case that we're here on today?
Yes, you contacted me asking me to review and look at the records to see what I saw in them, and not to prove abuse or not abuse, but to analyze the issues that are there. And I believe the date of that was May 2024. I think was when I was first contacted.
And it was actually Caitlin Gilbert is the one that contacted you, not me, right? Oh, okay.
Didn't write that down, but your office.
Right. So it was the Innocence Project of Texas.
Right.
Okay. So the Innocence Project of Texas asked you to review this case.
Correct.
Okay. Now, just to clear one thing up, you have reviewed cases for various innocence projects around the country, including the Innocence Project of Texas.
Correct.
And how do you handle fees to innocence projects when you get involved in cases?
I did not charge for review and consultation or the provision of testimony, but I want my travel expenses covered. It's people working as a volunteer effort, and I don't think that I should be charging money for that.
Okay, so on this particular case, you're not expecting to receive any fee.
I want my car travel covered.
Right.
Hotel bill.
Other than that.
Right.
Okay, so can you tell us what you reviewed in the Gardner case?
Yes, if I can look at my notes.
Yes, sir.
Okay, in the Garner case, I did get birth records. I did get the San Elizabeth records from the day of presentation. I received the records from the Children's Hospital, the San Elizabeth records from 225. I received the Children's Texas records from 225 through death. I received the volunteer statements of 3.3 and 308, and I received I received something that Dr. Lukerford, Dr. Alhoven. I received the autopsy from Patrice Moore, and I think that's. But in terms of imaging, the review of these cases always starts, if you're available, with the review of the imaging.
But you didn't have the imaging in your initial review.
That's correct. But the imaging did not really become available for me. Any imaging only became available about 6 to 8 weeks ago. And it did not include the first CT scan, but it did include a chest X-ray from the presentation and the second CT scan.
Okay, so in general, you reviewed the medical records, and did you review the testimony from the Garner trial from Dr. Stein and Dr. Moore?
That's correct.
Okay, so I'm going to come back around to that in a minute, but I want to talk about the Rourke case.
Okay.
Okay, because as you know from sitting in the courtroom listening to us discuss this, what this case is about is does the new science from the Rourke case apply to this case? You understand?
Correct.
Okay, and that's what you were told at some point we needed you to look at.
Correct.
Okay, now you recall coming to Dallas and testifying on the Rourke case.
Yeah, I did it years ago.
Okay, so does 2018 sound about right?
Right.
Okay, now, and of course, you became aware that in 2024 that the Court of Criminal Appeals granted writ relief and set aside Andrew Rourke's conviction.
Correct.
Okay, so you became aware of that because I guess everybody became aware of that.
Correct.
It works in this area.
Correct.
Right. Now, am I correct that the basis for the Court of Criminal Appeals to set aside the conviction in the Rourke case was the new science in the area of shaken baby syndrome?
Correct.
Okay, so I want to talk to you about some of the new science that the Court of Criminal Appeals identified in the Rourke case in their opinion. Okay, so one thing that they said, and this is something that applies specifically to the Garner case, is they talked about new science in the area of retinal hemorrhages.
Correct.
And can you just tell the judge in a way that maybe I'll understand, what is the new science in the area of retinal hemorrhages that the Court of Criminal Appeals identified in the Rourke case?
In the Rourke case, they concluded that retinal hemorrhages are nonspecific and would not serve then as a something to tell accidental injury from abusive injury from a natural disease process. This is fairly new because prior to August of 2018, retinal hemorrhaging from the American Academy of Pediatrics, it was extensive as it was in the Garner case, and from the U.S. Department of Justice own guidelines indicated that severe retinal hemorrhaging was, for all intensive purposes, basically proof of abusive shaking. Not abusive, but abusive shaking injury, short of a 60-mile-an-hour car wreck or a two-story fall. Retinal hemorrhaging, as was present in this case and many other cases, was to be taken as basically only explained by the repetitive rotational head accelerations that would be inflicted in an abusive shaking.
And so let me just back up for a minute. How did this whole concept of shaken baby syndrome come about to be considered in the courts in the U.S. and other countries? How did all this happen?
The shaking baby hypothesis was sprung out of the concussion research. They set out in the late 70s to try to induce concussion, loss of consciousness, by a rapid head acceleration, and then the Kathy and Gut Kelch and the early people then said, "Oh, this must apply to our babies who we see head injury on." So without validation, they simply asserted that the repetitive rotational head accelerations that would be experienced in the abusive shaking would be causing brain injury, retinal hemorrhaging, and subdural bleeding. And that became kind of it became accepted without validation as science. The first, before we kind of talk through some of that, I think, in particular in terms of reading the testimonies in this case, I think it'd be good to familiarize the court with what is exactly in the shaking hypothesis. The idea of shaking is the word shaking can mean many things, but the hypothesis as asserted is that you grab the baby by the chest and you violently move the chest back and forth such that the head has to flip from the front of the body to the back of the body repetitively. It is the rotation of the head through that flip, which is which was causing a rotational motion within the brain that was the injury. This is this rotational acceleration deceleration is the mechanism of concussion. That is not disputed. It's the level of this rotation that is necessary to reduce it. And before we go, if you think about it, when a boxer gets hit in the jaw, his head spins. It's not his jaw. The skull has not been hit. It's the spin of the head, which is the mechanism of his concussion. In football, I assume many of us here in Texas are football fans. If this guy is coming in and hits the front, with the top of his head, the front side of this guy's helmet, if you look closely on the video, there's an instantaneous flip. This guy's head does not rotate. This guy does not get a concussion. This guy does get a concussion. And if concussion occurs, the symptoms, the boxer's knees buckles and he goes to the ground. So that with a rotational acceleration, deceleration injury, the concept of immediate onset of symptoms enters the picture. And so that was incorporated into the shaking hypothesis, that at the very moment of the shake, not hours or days later, that if the brain has been injured by this rotational component, that the infant will become immediately symptomatic, not appear normal again, and not eat.
So the idea or the movement to prosecute people for shaken baby syndrome, tell me if I'm correct, that was kind of in the 1990s when it started happening with some regularity?
Yes.
Okay. Now, the doctors who were saying that infants were shaken, what were they saying they saw that led them to believe an infant had been shaken?
The findings, the classic findings would be that you would have the immediate onset of real symptoms, that you would have brain injury, subdural bleeding, and retinal hemorrhaging. And the hypothesis then was stating that as the brain is violently rotated within the skull, that you would get little tears in the axons. I can explain a little more in a minute, I guess. That would be the diffuse or traumatic axonal injury, and that the clear jelly inside the vitreous would be swirling around, ripping and tearing the retina, causing retinal hemorrhage, and the veins going from the surface of the brain up to the big venous collection system attached to the skull would be torn, causing subdural bleeding. So the classic constellation of three findings of the shaking hypothesis was subdural bleeding, retinal hemorrhaging, and since you don't really see traumatic axonal injury on imaging, then that these were taken as signs of proof of the axonal injury of the brain and accounting for the immediate neurological symptoms. So that since there is no conceivable, that I can conceive of, accidental repetitive rotational head acceleration, then if the diagnosis is appropriate and accurate and valid, then it does identify a crime. And since the symptoms would be immediate, recognizable, then the person with the infant at the moment, at the time of the onset of symptoms, would be the guilty party.
So when they talk about shaking, shaking baby, the shaking of the infant, what are they talking about on shaking?
This is important because I'm sure we've kind of forgotten our high school physics a little bit, but it'll come. But acceleration and deceleration can be linear, going from point A to point B, or it can be rotational, starting to stop spin. And and linear acceleration, deceleration is frequently reported in G's of acceleration or G's of deceleration. And rotational acceleration, deceleration is reported in a unit called radians per second squared. And I think I need to give a brief definition of what that is, because we ultimately start talking about numbers in this kind of research. And what I tell is that if tell a jury is that if you got your Ferrari, you got the engine, put it in and pop the clutch and go from 0 to 60 in 4 seconds. You've accelerated at 15 miles per hour per second for 4 seconds. So your acceleration is 15 miles an hour per second. If you take that same Ferrari and put it up on blocks, and you gun the engine, pop the clutch, and the wheels start spinning, and hit the brakes and the wheels stop spinning, your Ferrari has gone nowhere, but you have the start and stop of the spin. And the unit this is measured in is a radian per second squared. Now, if you, in your car, if the engine is idling at 1,000 RPMs, rotations per minute, then while the physicists and the child and the sports medicine people and environment can't do this, but they define each rotation is 6.28 radians is equal to 1 rotation. So something is spinning 1,000 RPMs is spinning at 6,280 radians per second, just like going from inches to centimeters. That's a direct conversion. And so then if that stops in 1 second, then you've had a deceleration. So you get your radians per second squared. So that the unit that this damaging rotational acceleration, deceleration is measured in is radians per second squared. And I appreciate, and I tell this to the jury, I may have lost you in that, but I tell them that you may not know what a watt on a light bulb is, but you know a 150 watt light bulb is brighter than a 50 watt light bulb. So that when we start talking numbers, research from the child abuse doctors, from this kind of research, we're talking numbers of radians per second squared.
So essentially, and tell me if I'm wrong about this, essentially what developed was cases that had the 3 symptoms that you have identified: retinal hemorrhages, subdural hemorrhage, and some sort of brain injury. And if a child had those 3 symptoms and there was no other explanation for what happened to them, it was said to be shaken. Is that a fair statement?
Correct. And it was felt to be, as 1999, it was felt to be such a unique constellation that it really, again, short of a 60-mile-an-hour car wreck or fall from a 2-story building, would require a shaking, a requisite component, shaking in the injury mechanism.
And the American Association of Pediatrics, the AAP, that's the professional organization of pediatricians, correct? They, back in the early days of this shaken baby syndrome, they gave a description of the kind of shaking that they said was necessary to cause this.
Correct.
And do you recall what that description was?
Well, I think I would say that the essential word in this is rotational. If I took a baby's head in my hands like this, and I shook it like this, that is, I'm not saying do it. I'm just saying that does not qualify as an abusive shake because it is non-rotation. And so that if a baby is laying on the bed and you bounce it up and down, that is there would be almost no rotational component to that. So the hypothesis requires that if you grab the chest, you have to oscillate back and forth of a distance enough so that as you push forward, you get enough velocity so that when you stop, the head has the momentum to flip over and flip back over and over. So that requires a great deal of gripping and traction and force on the chest back and forth. This is not an abusive shake. This is not an abusive shake. It has to be this rotational component, which the head freely able to go back and forth, to get, and as it's rotating, stops. It's at the moment stop that you get. Suppose there's the brain continuing on, independent of the skull, supposed to cause a stretching of the cortical of the bridging veins, causing it to bleed and tear, and causing the axons within the brain to tear and rupture, called diffuse axonal injury. And I would explain that this way: is that
Well, let me come back to that. Concerning what the Pediatric Association and the child abuse doctors say as far as the kind of shaking that would cause all this, am I correct that they say it has to be very violent and repetitive?
very violent and repetitive, because with a a single hit, it wouldn't be repetitive, like hit drop, short fall, or slam against the wall type of thing. That does not have this repetitive nature in it.
And they also say that it would be the kind of shaking that no reasonable person would think is normal child care.
That's correct in terms of watching participating myself, but in watching videos and published research. It is not this. It is not this. It requires that the body be moved far enough to get the velocity so that when you stop the body, the head flips from the front to the back of the body.
So we're talking about what the Pediatric Association and the child abuse pediatricians say is necessary. And would you agree with me that they say that no reasonable person, has to be the kind of shaking that no reasonable person would think would do anything other than cause serious injury to an infant?
Yes.
Okay. And so when that shaking allegedly occurs, that's when they say it causes the retinal hemorrhage, subdural hematoma, and the brain injury.
Correct. And that's a very important distinction, brings up the issue of primary injury versus secondary injury. That the shaking hypothesis indicates that at the moment of the shaking, you have the brain injury. At the moment of the shaking, you have the initiation of the subdural bleeding. And at the moment of the shaking, you have the rupture of capillaries causing the retinal hemorrhaging. You do not have a delay in the appearance of those findings. It is primary at the moment of the event. An example I use, maybe kind of crude, but as opposed to secondary injury. If I'm slicing up my tomato in my salad tonight and cut my finger, that's a primary injury. If in 3 days it gets infected, that's a secondary injury. Yes, it may have started to cut, but it doesn't always go to the secondary injury, but you can have a secondary complication. So in the American Academy of Pediatrics acknowledges that you can have a primary event, which might be the shaking or a fall or some medical, crush, trauma type of thing, that then causes a certain injury without necessarily injuring the brain, which would then set in motion a metabolic cascade or unfolding secondary pathologies, which then hours to days later could then lead to brain injury, retinal hemorrhaging, and subdural bleeding.
But their point is all of that is dependent upon a very violent and repetitive shake.
The shaking is violent, and I can tell you when I've
Well, let me ask you. So you have, I assume, been in trials and read transcripts where a child abuse physician who's describing the violent, repetitive shaking that's necessary, and a lawyer or a judge says, well, what else can cause this?
Right.
And they would say the only other things that could cause it were being in a high-speed automobile accident or a fall from a multi-story building.
Yes.
Have you seen that testimony before?
Yes, and that springs almost directly from the United States Department of Justice's 2002. There were earlier renditions, but that's verbatim, that a short fist and fall is fairly benign, and that retinal hemorrhages, for all intents purposes, is conclusive proof of shaking.
But let me stay focused for a second on this. So are they saying, when they say the only other things that would cause these injuries, other than violent repetitive shaking of this infant, is if the infant was in a high-speed automobile accident, or the infant fell off the second or third story of a building, that those are the only other things that would cause it? Are they saying that as much force is generated by this shaking as being in a high-speed automobile accident?
That's correct, and that was the basically the stated position of the American Academy of Pediatrics in the 2001 Department of Justice when this case was going down.
Okay, so this case was tried in 2004. And 2001, the AAP, American Association of Pediatrics, issued a position paper that talked about all this.
Correct.
Right. So that position paper is the paper that was in effect in 2004. Right.
Correct. And the title of that was Shaken Baby Syndrome, Rotational Cranial Injuries, a technical report. And I think that the first sentence of that is basically saying that we have now evolved to the point that the diagnosis of shaken baby syndrome, rotational cranial injury, is no longer a diagnosis of exclusion.
And let me get back to that in a second, but I just want to make it clear for the court that in 2001, there's a position paper by the Pediatric Association and this isn't like requirements for pediatricians, but it's suggestions on how to handle things, right?
Yes, let me tell you what these are. The American Academy of Pediatrics has multiple sections from breastfeeding to vitamins to immunizations to this kind of thing, and the subsection of child abuse and neglect, which I'm pay my dues, and I'm part of that. So I'm a member of the American Academy of Pediatrics, and each section is tasked with periodically reviewing the available considered state of the art. These are published as either technical reports, clinical reports, or policy statements. And they are published specifically as guidance for pediatricians in this country because these cases are rare. And a pediatrician could have a whole career and never encounter one. So if it comes forward, he needs a place to go to get the up-to-date thought.
So the 2001 paper, let's focus on that since that was in effect at the time of this particular trial. What was the guidance from the American Association of Pediatrics in the 2001 paper that was in effect in 2004?
That was that the diagnosis is no longer a diagnosis of exclusion. Means you don't really need a differential beyond a plan.
Okay, let me stop you there. What's a differential?
That's where when the patient presents with these findings in this clinical situation, that the standard medicine is you start with your list of all the possible explanations for those findings, and you start eliminating, excluding everything until you're left with the most logical what remains.
That's normal medical practice.
That's normal medicine to this day.
And in the 2001 paper that we're talking about, did they say that when an infant had these three conditions, that a pediatrician didn't have to do a differential analysis?
That sentence to me says that it is no longer a diagnosis of exclusion.
So what does that mean?
And that means that the presence of those three findings in the next sentences justifies a presumption. Actually use the word presumption of injury by abusive shaking when you had intracranial, subdural, subarachnoid bleeding, retinal hemorrhages, and some rendition of brain injury, swelling, encephalopathy.
So those three conditions became known as the triad, is that right?
Constellation of three findings, triad was short form of that. But in the time frame of Garner, they to have said that you had these findings, particularly retinal hemorrhaging, and say it was something else beside shaking, would have been going against the positions from the American Academy of Pediatrics in 2001.
So essentially, if the doctors in the Garner case that we're talking about, if they said, we have a retinal hemorrhage, we have brain injury, and even without subdural hematoma, but if we have a retinal hemorrhage and we have brain injury, therefore this was caused by shaking and nothing else, they would have been acting appropriately in reaching that decision based upon the AAP guidance.
I would say yes, particularly with the retinal hemorrhaging aspect, because retinal hemorrhaging was to be taken as basically requiring repetitive acceleration, rotational acceleration, deceleration to account for it.
So
because there happens to, you would like to have, they didn't address the issue. What if you only have two of the three, i.e. no subdural bleeding? Can you still call it shaking? I think with the retinal hemorrhaging component there, they would be hard put not to call it shaking, but I don't think that only having two of the three was directly addressed.
So the typical case that they were saying was a shaken baby syndrome case, typically would have all three: subdural, hematoma, retinal hemorrhage, and the brain injury. Is that right?
Right.
And in your review of, I think you said 400 cases, how often have you seen a case without a subdural hematoma that they claim fit into the shaken theory?
Almost, I can't. Very few. I've only rarely seen that, but it's just almost invariably subdural is the thing that usually starts the clock rolling.
So this case is unusual to begin with as far as claiming it's a shaking case, because the state's doctor said there wasn't a subdural hematoma. Right?
They called the reader of the CT scan we have did not document or did not mention any blood between the skull and the brain. I think that's an underread on his part, but he did not mention any of that. Right? He didn't mention any blood within the brain itself. He specifically said there's no evidence of blood in the tissue of the brain. He made no direct comment at all, just didn't mention any blood between the brain and the skull.
And I want to get back to that in a
Okay.
second. So when the doctors, or particularly Dr. Stein in this case, the Garner case, said based upon the retinal hemorrhages and the brain swelling, this was shaking and nothing else. He was following the guidance at that point.
Oh, yes.
Okay, so later did the AAP change their position on some of these issues?
Well, I would like to say also in 2001, yes, they did, but in 2001, they also said that the constellation of these findings does not occur in a shortfall. I know shortfall is not the issue, but a shortfall is impact to the back of the head. And in the Garner case, you have a history of an impact to the back of the head. How you equate those two,
And just to be clear, when you say impact, you're talking about hitting the child's head on the door.
hit a door frame.
Okay, all right.
The history that comes to the record is that he was holding the child in his left arm. The head was extended beyond. The baby would be looking up or down this way. And then as he turned to exit, the head impacted. And so in my reconstruction of that, if I'm the baby, then it would be the right back of the baby's head hitting the door frame. And that clearly, and he thought it was a pretty solid hit, but we don't have any way of measuring, studying, equating that account with a short fall. But in the 2001 timeframe, even if it had been a drop of 2 feet to the floor or 3 feet to the floor. The position of the Academy and the US Department of Justice would be that that would not account for the findings in this case, even if that such thing happened.
So the 2001 AAP paper said these things don't happen from a shortfall. Was there anything else significant in that 2001 document as far as it relates to this case that you could?
I don't think so.
Okay, so when was the next position paper issued by the AAP?
The next one I focus on is the AAP COCAN by Dr. Kellogg of 2007. And in the interim, what you had happening is that they had to respond to was that you had the emergence of biomechanical studies saying that the levels of acceleration, deceleration of a shaking would fall far short of anything that would be predicted to cause the findings that you're attributing to this shaking.
So what is biomechanical?
Biomechanical just engineering is the discipline specifically defined as a study of physical forces acting on living tissue. So it's the basis of sports medicine. It's the basis of your airbags, your car safety equipment, is of prosthetics, and it is the study of scientific study of physical forces acting on living tissue. The doctors would like to say, oh, we are the experts here. But when a patient is wheeled in on the stretcher, all battered and bruised, after the car wreck or whatever, or falling off the ladder, the doctor does not know the force with which the head hit the windshield, or it's the actual study of the forces involved in physical injury.
And these are PhD biomechanical engineers that are doing these
It's
studies.
a PhD level research engineering subspecialty. They do reconstructions of auto accidents, and certainly in civil cases of being sued for that or whatever. That is their game.
So you recall in the Rourke case that there was an affidavit submitted from Dr. Van E. It's V for the court reporter, VAN, then EE.
You know, I would object to the affidavit, any testimony about an affidavit submitted in the Rourke case. It's irrelevant in this particular case.
We are applying the new science to the Rourke case is what we're here for. So we need to talk about the science in the Rourke
And
case.
if I may judge even more than that, that's patented hearsay.
Your Honor, I'm just talking about what was in the opinion from the Court of Criminal Appeals in the Rourke case.
So his question started out about what was in the affidavit of Dr. Van E.
It's quoted at length in the opinion from the Court of Criminal Appeals.
Overruled, go ahead.
Okay, so you understand that the Court of Criminal Appeals in the Rourke case quoted at length from Dr. Van E's affidavit and relied upon it in reaching some of their conclusions about new science.
Right.
And what is your understanding of what the biomechanical engineering studies showed when they tested the shaken baby theory?
The shaking hypothesis, all the biomechanical studies, whether you talk about Prang or Dupain or Carol Jenny, about Coates, there's a number of these studies that try as hard as they can to reduce levels of this rotational head acceleration with abusive shaking, come up far short of what would be predicted to be necessary to cause primary brain injury, primary subdural bleeding. So that the way they studied this, of course, is they create models, mechanical models. So you see the car crash reconstructions with all the dummies sitting and you see them flying into the windshield. This is their kind of game. And they build these models and then they shake them to try to see what the measured level of rotational acceleration that can be generated is, and then try to see if that can be predicted to cause these injuries. And again, this is not just them alone. One study I rely heavily on is the Carol Jenny Aprika studies of 2002, where she, in coordination with biomechanical engineers and the Japanese Aprika car company, built two biomechanical models as accurate as they could, as the right size head, the right size body, the right range of motion of the chest. One weighed 2.5 kilograms, one weighed 3.4 kilograms, and they used the Krabby model from the industry for the 17-pound model. And they, with Carol Jenny, violently shook these models and then reported their data of the levels of rotational acceleration that could be generated. This data was available in 2002. The results of that, I think I mentioned these radians per second squared. In the shaking, they also reported the tangential linear acceleration, deceleration as the head stops, not only the spin, but the linear deceleration of the center of gravity. And out of that research, as one might expect, at the 17-pound model, the most they could produce was 560 radians per second squared.
Let me kind of cut through some of the details.
Right.
And ask you if it is correct that the biomechanical engineering studies were unable to replicate enough force to show that shaking alone could cause this triad of injuries.
That's correct. And of course, the child abuse community would respond by saying, oh, but your model is just not accurate enough. So in response to that, the Prang and Margulies, UPenn, said, we're going to set out to build a model which, with all of our technical know-how, to get the highest numbers possible with shaking. And if we do that and we still cannot get to levels predicted to cause injury, then we would have to say that further research with modeling is not going to be productive.
And is that what happened?
Yeah, in the Prime 2003, basically concluded that to date there is no data to suggest that the levels of rotational acceleration or deceleration would be able to produce primary brain injury or primary subdural bleeding.
And in the Rohr case, that was one of the areas of new science that the Court of Criminal Appeals relied upon specifically to show that there was new science concerning whether or not shaking alone can cause the injuries claimed to be seen in these cases.
Haven't read the reference list, but yes, that's the kind of data and the research that would have been quoted by these people.
Okay, so in addition to the biomechanical engineering studies that concluded that there was a question as to whether or not it was even possible to generate enough force to cause these injuries by shaking, did those studies also reach a conclusion about short distance falls? Now, we're not going to go into it deeply, but did they reach a conclusion about short distance falls?
Yes, and I think to give a number is a little bit helpful, because in Carol Jenny, child abuse pediatricians, shaking of a 3.4 kilogram model, she reported generating 1,430 radians per second squared and 10 Gs of tangential linear deceleration. I would chalk those numbers away because we can compare with them. But in dropping a 8-10-pound model, they're reporting like 20,000 radians per second squared. So that the difference between shaking and an impact, whether you say it's a fall or inflicted or slam against the wall or shaken, impact syndrome was the going verbiage. You shake first and slam the head to get shaking plus impact was the going terminology frequently. That it was the impact which was clearly capable of causing the injury, and the shaking was coming up short, and there was no validation that it was a valid producer of primary brain injury.
So essentially, is it a fair summary of the biomechanical research is that their research said it is unlikely that shaking could cause these injuries, but it is very likely that a short distance fall could cause these injuries.
Correct.
And that, in fact, was the exact opposite of the prevailing belief in the pediatric community that was dealing with these cases. Is that right?
Correct, but the pediatric community then responded by saying, "Oh, but we know babies. You just have your models, and we believe it happens. Therefore, we know it happens. Therefore, something that we don't want to accept what you are saying."
So the pediatric, when we say the pediatric community, I want to be more specific. There is such a thing as a certified child abuse pediatrician. Is that correct?
That's correct.
And these are pediatricians that focus on evaluation of child abuse, and primarily in the big cities and the hospitals in the big cities. Is
That's
that right?
correct. And the child abuse subspecialty was not created in 2009. So before that, all who engaged in this area were just pediatricians, neurosurgeons, are engaged in the area.
But my point is that there were pediatricians who dealt with these cases who disagreed with the conclusions of the biomechanical engineering studies. Is that a fair statement?
Correct.
Okay, not obviously not all pediatricians, because I assume you didn't disagree with it.
Well, I was not, I was following that. And I was not believing I was agreeing with the biomechanical because at that point in time, I was going into lab.
Okay, so there was a dispute in the community of experts who deal with these cases between biomechanical engineers and child abuse pediatricians on just focusing specifically on one of the issues in this case, a disagreement between those two areas of specialty on whether or not the science supported the theory that shaking alone would cause or could cause retinal hemorrhages, subdural hematomas, and serious brain injury.
That's correct. And
So you had those two different areas in dispute.
you had this emerging discrepancy between the prevailing opinion of the clinicians versus the reported research from the biomechanical folks. And this was undercurrent up until you got 2007, 2009, and the next flag posts we probably get to.
But so this dispute is going on, and then at some point, did the dispute and the new information that was being put out into the community, did that alter the American Association of Pediatrics advice on this area?
Yes.
How did it alter?
Well, I specifically at this point would point to the American Head of Pediatrics physician authored by Dr. Kellogg at San Antonio of 2007, in which the quote was, "Most of the recent advances have come in the recognition of mimics." In other words, in 2001, there was no such thing as a mimic.
What do you mean a mimic?
That is something besides shaking, which can cause exactly these findings. But between 2001 position and 2007, things were being recognized: crush injury, that type of one, medical follow that could end up with exactly the same findings and that need to be considered. So in 2001, when it said it is no longer a diagnosis of exclusion, nothing else has to be ruled out. By 2007, the onus is now on the evaluators to create a differential diagnosis and start eliminating things to rule out before concluding that this is abusive injury from shaking.
Okay, so that was something new that came up as a result of the research and discussion in the community.
Correct.
Okay, so was there when was the next official paper from the AAP issued?
In 2009, but before we leave 2007, in the section of that Kellogg paper, they talk about retinal hemorrhaging, and they define it a little further, trying to say that when retinal hemorrhages are of a certain pattern and severity, it is much more indicative of abuse. Interestingly, in 2007 was the first abstract release of the first piglet studies trying with animal models to reproduce retinal hemorrhaging with this rotational acceleration, which was not panning out. So in 2007, the American Academy of Pediatrics child abuse doctors were challenged to validate or prove that this mechanism is actually a primary cause of retinal hemorrhaging, or particularly a unique pattern of retinal hemorrhaging. So that that was published response to the Kellogg paper. And so coming forward from there, you're approaching now 2009. And in 2009,
And let me stop you for a second, because you mentioned the piglet studies. So there were piglet studies and there were baby lamb studies.
correct.
And both of those studies, just shorthand, basically what they were doing were shaking these baby animals.
But they were not even published yet. There was just a glimmer of an abstract presented at a meeting that they were forthcoming.
The question I'm going to ask you about those is, when those studies were published, there was a series of lamb studies done by a researcher named Finney, right? Is that correct?
Correct.
And then there were baby piglet studies by some researchers led by a researcher named Coates.
That's correct. And the Coates, Margulies, Benenbaum, an ophthalmologist. A study was not actually published in 2010. And the first Finney study was published in 2010, and the second one in 2012.
But these people that were doing these studies, they were not people that were opposed to the shaken baby theory. They were basically supporters of the theory. Is that right?
Oh, that's correct. Gil Benenbaum is head author on many of the articles relevant to this case. But I think the important thing I don't want to skip over is that the 2009 recognized that that the controversy in this area remains. 2009 is the first recognition from the American Academy of Pediatrics that in terms of the abusive shaking mechanism, that there is controversy.
Okay, so back in 2001 and 2004, the official position was there is no controversy. This is well settled.
There's no longer a diagnosis of exclusion. These findings equal a diagnosis. By 2007, we can have a few mimics that have to be looked for. By 2009, they are saying that while shaking has the potential to cause an injury, shaking plus impact or impact does cause injury. Injury is undefined. They did not say that, but this is coming forward, and they acknowledge that to date, the 2009 position statement by Cindy Christian and Robert Block, that child abuse pediatricians, that the biomechanical studies have both supported and challenged the shaking hypothesis, and that the only real evidence we have that supports the shaking hypothesis is the confession literature. And in it, Cindy Christian goes on to comment that with an injury, you can have secondary unfolding pathologies, not that you may have a primary trauma, but then that causes a chain of events getting you to a metabolic cascade of problems. And at the top of the next page, it acknowledges that, that in this area, controversy remains. It goes on to say that the findings of accidental injury and abusive injury can overlap, so there's no clear pathology that proves shaking versus injury from accidental versus abusive. And then it goes on to say, and I think this is very important to get out, very clear, because they go on to say that we no longer want to refer to it as shaken baby syndrome anymore, because that implies a specific mechanism of injury, i.e. shaking. And if we say shaking, it is distracting us from convicting the perpetrators of these crimes against children.
So these are all things that the AAP put into their 2009 position paper. And you mentioned Dr. Christian. Dr. Christian, was she one of the authors of that position paper?
Yes, and Dr. Robert Block.
And they are strong, or were strong advocates of the shaken baby theory.
Yes, and Dr. Robert Block was the prime mover in getting the basic child abuse subspecialty initiated, and I understand he was certificate holder #1 of the child abuse subspecialty.
So in 2009, they made significant changes, as you've described, from what their position was in 2001 concerning this.
Correct. They acknowledge controversy.
Okay.
They say we don't want to call it shaken baby anymore.
Okay, let's stop right there. Don't want to call it shaken baby anymore. Were they so they were clearly advising the child abuse pediatricians who come into court and testify on these cases. They were saying, don't come in and say this was caused by shaking.
That's basically what they were saying, and they were saying that because they said, if we say pure shaking, we don't have the evidentiary support to back it up. And they say the time has now come for the adoption of a new term to be inclusive of all mechanisms by which a caregiver could inflict injury on an infant or child in their care. And we want that term to be abusive head trauma. So
now when a child abuse pediatrician testifies, they don't want to say shaking. They want to say abusive head trauma. Right?
They didn't want to say abusive head trauma, which is non-specific for mechanism.
No, so was the AAP saying we can't really prove shaking caused these injuries, so don't commit yourself to shaking. Don't say shaking, just say abusive head trauma, because that's a broad term that can encompass any number of things.
That's what they were getting across in their verbiage. They said, we don't want to call it shaking anymore because the only evidence we have for its validity is the confession literature.
Okay, so the confession literature, I'm not going to really talk to you about that, but you understand that Dr. Edwards, who's on the state's witness list, that he is the author of the leading article in the child abuse community concerning confessions related to abusive head trauma. Do you understand that?
I understand that.
And that we did do a deposition of him prior to this hearing that has been submitted to the court where we discussed that at length.
Right.
Okay, so we're not going to spend time on the confessions, but I want to back up just a second.
Okay.
Okay, you have something you really want to say.
I want to say this so bad I can taste it.
Okay, all right, say it.
Okay. The term abusive head trauma is non-specific for mechanism. And I tell this to everyone I talk to is that to claim an injury, to claim a crime, without saying how that was committed, how that injury was inflicted, is not helpful. A kind of a ludicrous example I would give would be to get away with the term abusive head trauma, has the adjective abusive. Head trauma, which all kinds of head traumas, is the equivalent of an adult murder trial where the prosecutor comes in and says,
Judge, I would object to this response. He's invading the province of you, the fact finder, by talking about what constitutes a murder or what constitutes the manner and means in which an offense can be committed.
Judge, he's just trying to explain what he's saying. And
Let's just go, I'm gonna sustain it and just let's do asking question and answer.
Well, I want to move on to a slightly different thing that's covered here. We were talking a few minutes ago about the animal studies, piglets and lambs.
Right.
Now, am I correct that there was a whole series of lamb studies? There were several piglet studies, and one of the conclusions from all of those studies was that vigorous shaking, even more vigorous than is proposed to happen in shaken baby syndrome, that vigorous shaking was shown not to cause retinal hemorrhages.
Yes, if I can give you the numbers on that.
Okay.
Okay, at the 2010 National Shaken Baby Meeting in Atlanta, Georgia, Dr. Robert Block, in his keynote address, said that valid causation must be able to demonstrate that it can cause a finding and that it did cause a finding. That is a statement of basic scientific principle. You start with hypothesis and you test that hypothesis to demonstrate its validity. And if you do, then the hypothesis becomes a theory that stands until it's proven otherwise. So that's 2010. And coming forward from 2010, what you have, in my opinion, is these 4 studies where they set out to demonstrate experimentally that the levels of rotational acceleration, deceleration would actually be a cause of retinal hemorrhaging, brain injury, and these kind of things. And the answer to that was the 2010 Coates, Margulies, Binnenbaum ophthalmologist at the University of Pennsylvania published the results of the first piglet study, which had been in the works for about 2 to 3 years. What they did in this study was they took these small little piglets, which is considered to be an appropriate animal model to study. Size is very important. The piglet eyeball is 16 millimeters. The infant's about 18, 20 size. It's not like a mouse eyeball. You're talking about something of a comparable size of a mammalian model. They hooked their mouth to a bite plate and then hooked it to basically a jackhammer. And when they fired this thing, the head was violently accelerated to a 130-degree arc and then violently decelerated, all without hitting the head, all within about 15,000th of a second. That is an acceleration to greater than 50,000 radians per second squared. Dr. Binnenbaum goes over with his ophthalmoscope and sees no retinal hemorrhaging. Now, at autopsy, they did see some hemorrhage up in front of the eye and around the edge of the ciliary body, which is right where the colored part of the eye kind of hooks in. But that's not where retinal hemorrhages are seen in these kind of cases. So they had failed to produce grossly visible retinal hemorrhaging with this single massive move. Their answer to that was, well, because in the shaking, it has to be repetitive. It's not just a single rotation, it has to be the repetitive type of motion. Coming forward from that, we then have the Finney studies of 2010 and 2012, where Dr. Finney took little lambs between 10 and 22 pounds, grabbed each one by the chest and violently shook it for 10 30-second sessions. That's 5 total minutes of shaking. He was not measuring the levels of rotational acceleration. He was simply doing as violently as he could for 10 30-second sessions. And at the end of that, he then sacrificed the lambs and reported reducing no grossly visible retinal hemorrhaging or no macroscopic subdural bleeding. So no microscopic, MAC means so big that you can see it without a microscope. There were, I think, 2 of the lambs had some microscopic hemorrhage, but nothing that an ophthalmologist would see without looking under a microscope. So they and between 2000, that's 2010 plus 2012. And I will comment here that 3 of the smallest lambs died before sacrifice. Died before sacrifice. So the idea that this was just benign and they just danced back to the yard and played with their friends. 3 of them died, but he didn't say why. So I approached the authors and said, "What did they die of?" Because the lambs were on a ventilator. It is hard to die of a brain injury when you're on a ventilator. And the answer came back that they died of cardiorespiratory arrest. Again, you don't die of respiratory arrest on a ventilator, but then I kind of that's a massive amount of chest trauma in that scenario.
So what did
Let's- Mr.
I'm
Richardson, if this is a decent
It's-
spot, let's take just a quick 10-minute break. It's about 10 minutes till 11. We'll try to get started at 5 minutes after 11. And I don't need anything else. Yeah, all right, we'll take just a short break. Court will be in recess. All right, back on the record, applicant, present, defendant is here, or Mr. Garner. State's attorneys are present. You may proceed.
Thank you, Your Honor. Dr. Glasnick, I want to focus a little bit on retinal hemorrhages again. Okay, so the animal studies showed that the shaking didn't cause retinal hemorrhages. The biomechanical engineering studies showed the same thing. So where are we now on the question of whether shaking alone? And I want to make sure it's clear, the question is about shaking alone with no impact. Where are we now as far as the science goes on whether shaking alone will cause retinal hemorrhages?
First of all, I'd like to say that the final pivot study was 2017.
Okay.
We didn't get to that, and I think that's important.
Okay, well, you're right. So what's that final piglet
Well, the
study?
final piglet study was, and the importance of this to me is, they went back to the piglet model and they rigged up their machine to deliver cyclical. Remember, the early said it wasn't repetitive, it's got to be repetitive. So they went back and now it was cyclical, delivering repetitive rotational head accelerations. For up to, I think the group that got the most got 2 30-second sessions. That's 1 total minute of this repetitive effort. And at the end of that, they saw no eye findings at all. None. And the importance of that study to me is that the authors are Coates, Margulies, biomechanical engineers, Dr. Duhame, a neurosurgeon, and Dr. Cindy Christian, a leader of the child abuse community. She is part of that research. She is author or co-author of the 2007, 2009, 2010, both 2013, 2014, 2015 consensus statement in 2018. That is her resume of contributions to this area. And she was part of this research. And with 1 total minute of repetitive rotational head accelerations, they had failed to produce any eye findings. So that was published on January 1 of 2017.
And when you say any eye findings, you mean the retinal hemorrhages that are alleged to occur in shaken babies?
They were not seeing anything with their ophthalmoscope or when they sacrificed the animals and sliced it open and laid open the eyeball. So that was 2017. And at that point in time, in 2010, in the position statement authored by Cindy Christian and Alex Levin, they had made the statement that when retinal hemorrhages are extensive in all 4 quadrants to the 4 extremities, it is repetitive acceleration, deceleration, as opposed to single impact trauma, which is the critical factor in causing retinal hemorrhage. That was the position in 2010, renewed in 2015, and should have been good until 2020. But in the interim between 2010 and 2017, all experimental efforts to confirm that repetitive rotational head acceleration at levels that might be generated in abusive shaking was even a valid cause of any grossly visible retinal findings had failed. So the very thing that for the previous years had been assumed to be pathognomonic for shaking.
What
Could
is
be,
pathognomonic?
it has to be, it's just their presence leads one to conclude that a requisite component of shaking had to have occurred, had failed validation. So the very thing which was basically the cornerstone was suddenly found to not be able to produce any grossly visible retinal hemorrhages by primary mechanical event as asserted in shaking. Now, I make very clear, I'm not saying shaking is benign. I'm not saying you could not shake a baby, break its neck, injure spinal cord, baby stop breathing for 20 minutes, get resuscitated, brain swell, pressure goes up, coagulopathy develops, and you end up with a retinal hemorrhage. What I'm saying is that in order for retinal hemorrhage to be a deciding factor in determining abuse versus non-abuse, it had failed all validation.
So at the time of the Gardner trial in 2004, am I correct? The position was any kind of retinal hemorrhage means that there was shaking.
Correct.
Then they later changed to say, okay, that's wrong. So they changed the position. They said certain kinds of retinal hemorrhages mean there was shaking.
Correct.
And then all this other research was done, including the animal studies.
Right.
And what's the scientific belief on that now?
Well, and given that Cindy Christian was author of the 2010, 2015, and part of the research which had failed to validate what she had been saying, she had to do something. So the American Academy of Pediatrics, in August of 2018, published its early revision of the 2010, 2015 position statement. That position statement should have been good till 2020. But the emergence of this literature, this research, failure to validate what they were saying, forced their hand to do a revision 2 years early. And when they did it, they downgraded the wording to something like, when retinal hemorrhages are extensive in all 4 quadrants, that vitreoretinal traction from repetitive is a contributory factor, but retinal hemorrhages have many causes, particularly in sick infants. To me, that is more than that's a 180-degree turn from what previously had been. It was the critical factor as opposed to any single impact trauma. It has now been demoted to possibly a contributory factor, but retinal hemorrhages have many causes. Therefore, the position is that retinal hemorrhages are they can occur in many different conditions, and that they are probably since they are there in these kind of cases. I'm not saying that kids don't have retinal hemorrhages, but the mechanism that causes them has to be something else. Increased pressure, infection, coagulopathy, bleeding disorders. Something else has to be the primary cause of that finding, and since it's secondary, a number of different processes could get you to a metabolic cascade, a chain of event, to get those retinal hemorrhages there.
And of course, you know that Dr. Stein, in this case, in the Garner case, relied very heavily on the presence of retinal hemorrhages in saying this was caused by shaking.
Correct. I know that. And I also know that testimony would have probably stood through 2015 because that position, because the retinal hemorrhaging in this case would be as such that through 2015, the position would be that repetitive acceleration, deceleration, as opposed to single impact trauma, would be the critical factor. But yes, he was testifying exactly in line with the ongoing position. But given the failure of all the efforts to demonstrate experimentally. Not to say we looked at 100 babies we thought were abused and saw retinal hemorrhages, therefore we know that they had to have been shaken. But as Dr. Brock said, valid causation must be able to demonstrate and causation, and all efforts to demonstrate retinal hemorrhaging as a primary result of mechanical trauma of a rotational acceleration deceleration, as in a shaking or in a shortfall,
So,
had failed.
so, you understand, the Rourke case, one of the pieces of analysis from the Court of Criminal Appeals is that if a state's expert came in and testified the way they did in the Rourke case in 2000, they would, I'm
I think they're going to case.
yeah, if a state's expert testified the same way in 2026 in the Rourke case that they testified in 2000, they would be confronted with 20 years of research that contradicted their testimony.
Yes,
Now,
and
what we're, so here, applying that same concept here, if this case was retried today and Dr. Stein got back on the witness stand and said the retinal hemorrhages proved this was shaking and nothing else, it was shaking, then the jury would at the very least been
Your Honor,
informed.
I would object. That's a misrepresentation of Dr. Stein's affidavit and testimony. There was more than retinal hemorrhaging, Your Honor.
Your Honor, I'm talking about his testimony about retinal hemorrhaging.
That's fine. Go ahead.
Okay, so if Dr. Stein said the retinal hemorrhaging proves it was shaking that caused it, the jury would hear about today the piglet studies, the lamb studies, the other reports of things other than shaking causing retinal hemorrhages. They would hear all that today, right?
yes.
But back in 2020, and when this case was tried initially, 2004, those things didn't exist.
That's correct.
Okay. So let me talk to you a little bit about some other areas of new science. Okay. We have talked about shaking. We've talked about retinal hemorrhages. Shaking alone, am I correct that the primary basis of new science that proves shaking alone doesn't cause these conditions is the biomechanical engineering?
Yes, that is the experimental validation. Yes, the scientific has failed to look at it closely, look at it from different angles, and from every angle it has failed validation in terms of the retinal hemorrhaging point of view.
Well, I'm talking about the shaking alone.
Shaking along.
Okay, so the biomechanical engineering studies and research and experiments have failed to confirm that you can cause these injuries by shaking alone. Correct?
Yes.
And there are still some medical doctors, like child abuse pediatricians, that still claim you can cause these conditions by shaking alone. Is that right?
Yes, and when I use the word cause, I want to be very clear that when you say resultant, cause, primary versus secondary, it gets muddy. In other words, I routinely testify, I think I could kill a 8-pound baby by shaking. I think I would grab it by the chest and shake it like this. The head would flip back and forth, the neck would break, the spinal cord would be injured, the baby would cease to breathe for 20 minutes. EMS would get there, they'd resuscitate the baby, the brain would swell up from lack of oxygen, the pressure would go up inside the head, DIC would develop coagulopathy, and you could have god-awful retinal hemorrhaging in that situation. But the injury was to the neck, and the retinal hemorrhaging was secondary consequence of the metabolic cascade.
And in these cases, are they seeing neck injury?
No, they're looking for it, but not seeing it.
And so,
But they said that they're looking for evidence of it, and all they're ever finding is a little bit of edema on the MRI back here, but they're not demonstrating structural ligament failure of the neck, which is what would be predicted by the biomechanical studies on human infant tissue.
So the biomechanical studies have shown that if you actually shook a baby and hard enough to cause the subdural hematoma and the retinal hemorrhage, you would cause neck injury. Isn't that right?
If, well, first of all, we've ever actually shown that you could even get to the retinal hemorrhaging, but if you actually violently shook a baby,
If you could,
before you get to anything going on in the head, you would predict structural failure of the neck.
and the fact that they are not finding structural failure of the neck, what does that tell us?
That means to me that in the absence of ligament failure, I'm not talking about a little edema fluid in the muscles back here, I'm talking about absence of ligament failure of the neck, then leading to a primary prolonged respiratory cessation that I don't see that the baby has been shaken.
And that's the conclusion that's been reached by the biomechanical engineers in their studies.
They're saying that if you shook a baby, you would predict a ligament failure of the neck.
Okay, so I have read some comments by some child abuse pediatricians that basically say, well, we have proof, the biomechanical engineers are wrong. We have proof that shaking can cause the triad of injuries. And our proof is confessions, observed shaking, and animal studies. Have you seen those kind of
I've
comments?
seen those kind of comments, but I would also comment that that we have human research, which is also failing to show the same thing.
Okay, so that was my question, is they seem to rely upon confessions primarily. They bring up observed shaking, and there's some very odd, weak studies in that area. And then the animal studies. Did the animal studies show that you can shake these animals in a violent way and cause the subdural hematomas that they claim are seen in shaken baby?
No, they did not. And their answer to that was, but those are animals. We know babies.
Okay,
And you can't test about and you can't test a baby. Go ahead.
And you said that earlier, and I think what you're saying, and tell me if I'm wrong, it sounds like what you're saying is the child abuse pediatricians taking that position is they're basically saying, forget all the scientific research, we just know it when we see it.
Yes, and they're saying that we know you can't test babies, but I disagree. We have human infant data on repetitive rotational acceleration, deceleration of the head. And so what we have data on is not necessarily what the injury threshold is, but what the level of rotational acceleration, deceleration that can be tolerated without injury. That makes sense?
Say that again.
I say, they say we don't know the threshold for injury, therefore how do we know? But what we have is the Bouchon 2009, the Lloyd 2011, and the Daniels 2012, where we have studies of human studies, where they put monitors on kids' heads, and they record the levels of rotational acceleration, single event and repetitive event, and say how much is this baby's head or child's head experiencing repetitive rotational head acceleration without obvious injury. So they have established a level of tolerance for this mechanical event that is known to be non-injurious. And in this area, we have the Bouchon data. Bouchon took accelerometers, put them on kids' playground recess, running around, running and jumping, playing dodgeball, and simply jumping rope. As the head does this with each with each bounce, reported that they're experiencing 1,600 radians per second squared repetitively for the playground, and they're not going back to class blind and brain damaged. Now that is so that if you're going to say, remember 1,600 is what they're reporting, and the most Carol Jenny, child abuse pediatrician, was reporting in her shaking of her less than 8-pound model was 1,400. So we know that kids at spontaneous play are repetitively self-generating more rotational acceleration, deceleration than could be generated in the abusive shaking. Then we have the Lloyd data. I'm on this one now, okay? Where Dr. Lloyd had a 7-month-old son who loved his jumper rope, which is basically like jumping rope. And this kid loved bouncing up and down and squealing with joy, and his head just doing this the whole time. And accelerometer on the son's head reported 960 radians per second squared, with obviously no injury. I mean, a kid, not brain dead and growing up just fine, my understanding. So that what we have is we have and the Daniels data is Pee Wee football, where they have these helmets. College students have this too. College helmets, where they have football helmets, which have accelerometers in them. And during a game, information comes to the sideline and said that guy just took a 10,000 radian per second squared hit. Let's get him over and see what he's got. And the college football data I'm familiar with is out of Virginia Tech, and they report that the minimal level for a concussion in college football, this is not carried off a field, this is just a little fuzzy getting back to the huddle, is 9,000 radians per second squared. And Dr. Daniels, with his Pee Wee football data, reported that at routine Pee Wee football practice, the kids are experiencing 1,000 to 2,200 radians per second squared with no observable problem, and one recorded event up to 7,000 radians per second squared with no documented injury.
So that's medical research on real people.
Real humans.
Okay, so you've got the biomechanical, the animal studies, the medical research on real humans that all fail to support the shaking alone theory.
Correct.
And let me ask you about the Swedish study. And because I understand that there was a study out of Sweden that looked at the evidence that was claimed to support the shaking alone theory. Can you tell us about that?
Yes, in Sweden, it was a more socialized country. They've got socialized medicine. They have a committee whose function is to assess the quality of research. If we're going to pay for it with government funds, we want to make sure we get quality and not be going down rabbit holes. And so this committee undertook the evaluation of the quality of the evidence base for the abusive shaking hypothesis. They were very clear. We're looking at abusive shaking. They did not use abusive head trauma, non-specific terms of abuse.
And they're talking about shaking alone.
Shaking, abusive shaking. And they found that there was really almost no high quality evidence that support that the triad constellation of findings could serve, it was a valid diagnostic criterion, or that shaking was even a cause of any of the, no high quality research that shaking was even a well-supported cause of any of the components of the triad.
Now, you're familiar with the Neves case from New Jersey, where the New Jersey Supreme Court ruled that evidence claiming shaking alone
I would
causing.
object, sorry, Mr. Gashin, to a reference to a New Jersey Supreme Court case which has no precedential value in the state of Texas.
Your Honor, it discusses the science, and that's what I'm I'm not arguing that this court's bound by it, but it discusses the science, and that's what I want to talk about.
Overruled. I'll let you get into it. Just not, those don't go very far.
Okay. So you're familiar that the New Jersey Supreme Court ruled that testimony that shaking alone would cause or could cause the injuries we're talking about is heretofore inadmissible in New Jersey courts.
That's correct.
And they did that, they issued that ruling based upon the biomechanical engineering studies. Is that right?
They had a Daubert hearing with biomechanical engineers and pediatric neurologists testifying and radiologists, I think, testifying. And the conclusion of that is that they did not support the shaking hypothesis. They even said that the very term abusive head trauma is not allowed in that situation.
Okay, so we've talked about the Rourke case on the various some of the areas of new science that they found. Let's talk about lucid intervals. What's meant by a lucid interval?
Lucid interval means that between the point of the trauma and the onset of clearly visible symptoms, there can be a space in time. Now, if the abusive shaking hypothesis is valid, and if it is appropriately applied to a case, then at the moment of the shaking, you would have primary brain injury, i.e. a concussion, and the symptoms would be immediate. That's come through very clearly. However, if the injuring event is impact, which then sets in motion secondary processes that become symptomatic at a subsequent, after minutes or hours or days, then a lucid interval is very valid. This is clearly recognized in terms of impact injury, because in every emergency room in America, if you come in and say, I fell off my bicycle, I hit my head, and I got this bump over here. I said, well, you look pretty good. Here's your head trauma sheet. We're gonna send you home, but if at any point in time you start vomiting, get sleepy, please come back so we can do a CT scan to make sure we don't have increased bleeding or unfolding pathology in your head. So the idea that impact can come with a lucid interval is, every emergency room in America has that. And the same is true for the shortfall child literature. That child falls, hits his head, looks pretty good, sent home, deteriorates and comes back and dies. So that the idea that there's a videotape shortfall presented in 2011 abusive head trauma meeting in New York, where the child fell 30 inches off a toy in a mall to a rubber matted surface, cried a little bit, looked pretty good, but mom was concerned because she witnessed it, took the child to the emergency room. They said, he looks great, he's running around, send him home. And he died. And subsequently, so that was such a shocker, it became the keynote presentation at the 2011 meeting. A footnote on that is that they went, the medical examiner at New York City coroner's office and the child abuse doctor were so stunned that they did a massive coagulopathy workup on the family and discovered that the mother, unbeknownst to her, after 30 years of age and multiple kids, had a factor 13 deficiency. And they then decided, well, maybe this is a rare exception because maybe the child had the factor 13 deficiency. But they didn't test the child for the factor 13 deficiency. And factor 13 is an autosomal recessive. So that unless the mother married a cousin or a brother or somebody, the chances of that child having the factor 13, but that was a videotaped. I got the videotape.
So that proved on videotape that you can have a lucid after having an incident that caused a brain injury.
That sets in motion. You use the word brain injury. Set in motion a head injury, which then ultimately results in brain injury.
Okay. So now the Court of Criminal Appeals in the Rourke case noted that in that case, the state's experts said there is no lucid there is no lucid interval. If something happens, the result is immediate. The child crashes. Kind of like what Dr. Stein said here. Is that right? Is that your understanding?
Correct. If shaking is the mechanism and if it were valid, the symptoms would be immediate. And so he believed shaking said that in the corner case.
And so the Court of Criminal Appeals found new science rejecting that theory of no lucid interval.
Right.
And one of the things they cited was testimony from Dr. Matthew Cox, who's a certified child abuse doctor who worked in Dallas at one point, where he testified that you can have lucid intervals. Are you aware of that?
I'd have to go back and double check, but the impact injury is just the last 50 years, you have lucid interval.
Well, so am I correct that the importance of showing that you can have a lucid interval is that it takes away the main way that the state is able to say this person with the child, when the child becomes symptomatic, did something, as opposed to somebody else earlier having done something? Am I correct about that?
You're correct on that, that if the symptoms by definition have to be immediate, then the caregiver at the onset of symptoms is the guilty party. If the impact event or some kind of medical problem is setting off this chain of events, then you can have these findings from an infection. The baby could have had COVID for 3 days and then suddenly gone down into seizure coma and had a lot of these findings.
But even if the child abuse pediatrician's theory concerning shaking, even if that was true, the fact that you can have a lucid interval takes away the ability for them to say he's the guy that did it.
Correct. If I'll answer this is yes, it takes away that ability if they can prove that the shaking hypothesis was valid and applicable in that case.
Well, right. And I guess what I'm not saying this very clearly, but obviously in a criminal case, it is important for the state to prove that the person accused is the person that did whatever it is they say was done. Right?
Correct.
And the way they show that in these cases is by saying there is no lucid interval. If this happens, the child crashes immediately.
Correct.
And so the Court of Criminal Appeals has found that that is bad science.
There can be a lucid interval in certainly in impact cases, in medical mimics, so that that's you cannot definitely conclude that the person with the child is the guilty party.
And you understand in this case that the accusation against Mr. Garner was made because he was the person with the child when the child became symptomatic.
That's an objection, Your Honor. That's a misrepresentation. There was more to why this defendant was charged with the charges in this case.
That's overruled. Go ahead.
So you understand that Mr. Garner was with the child when the child became symptomatic. You understand that?
Yes.
And that led the police to make this accusation against him.
Correct. And that they were then pinpointing the time of the infliction to something like between 1 and 3 o'clock on the afternoon of the 25th. And that the fact that the child had taken a bottle, I think late morning or noon, would prove that the injury could not have occurred before that point in time, I think was in the testimony.
But if if lucid intervals are possible, is there any explanation in the literature as to how long a lucid interval could be?
It can be, no, it could be hours, it could be days. And some literature suggests that it, could be as long as a week.
So if somebody else was with the child in the Garner case earlier in the day, and there is clearly the possibility of a lucid interval, you can't say that Garner did something to this child when the child was alone with him. Is that a fair statement?
That you can't say that he did something to the child between, 1 and 3 in the afternoon. He could have done something in the morning, the mother could have done something before she left to work. You cannot be that precise.
Okay, let me shift gears a little bit and talk to you about some of the testimony from the Garner trial. Now, you understand that the state called 2 medical doctors in that trial.
Dr. Moore and Dr. Stein, I believe.
Right, Dr. Moore and Dr. Stein. Let's talk about Dr. Stein's testimony first. He's their main medical expert. Okay, now Dr. Stein, he saw the child when the child was transferred from Beaumont to Texas Children's Hospital in Houston.
Correct.
Right. Now, Dr. Stein, one thing he said, he was asked, can you tell the court how many times you've examined personally children that you've reached that ultimate conclusion as to shaken baby syndrome? Essentially saying, Dr. Stein, how many cases of shaken baby syndrome have you personally seen? And he said hundreds of times. Did you remember that testimony?
Yes.
Okay. Is it possible that this one doctor, Dr. Stein, has seen hundreds of shaken baby syndrome cases?
The reported incidence of abusive head trauma coming to a legal dispute or whatever in court is estimated about 1,000 to 1,200 a year. So that that's for the entire country. So that if there's, let's say there's 100 children's hospitals in this country, then I think to say that you were seeing more than 10 a year would be surprising.
So, and of course, we don't know why he said it, but I will tell you, he said it twice. So
Okay.
It wasn't an accident.
Right.
Okay. So, throughout his testimony, and in fact, throughout this trial, they continually, everybody was talking about shaken baby syndrome. Now, if a case was tried today, would the state's doctors be using the terminology shaken baby syndrome?
No.
They would avoid that at all costs.
By the 2009, they're not supposed to use that term. The medical record, it is not appropriate. The medical record, it should not be appropriate in court, I wouldn't think.
So in 2004, Dr. Stein was asked, now, is it true that shaken baby syndrome can be misdiagnosed? And he said yes.
Okay.
Okay. I presume you agree it can be misdiagnosed.
I agree with the diagnosis. I don't remember the exact point. But yeah,
Okay. But
I just think that
just give us a short explanation of how shaken baby syndrome can be misdiagnosed.
well, if your diagnosis is basing on the constellation of 3 findings, the triad, and other things can cause the triad, you could miss them. So that and remember, the consensus statement states that the diagnosis of abusive head trauma is not made until all plausible alternatives have been excluded. So that if you make a diagnosis of shaken baby and there's plausible alternatives out there that you've not excluded, you shouldn't be able to do that. The second thing is that if you're making a diagnosis now of shaken baby syndrome, on on a case, basing it on the three findings, then, and all the biomechanical and animal and human experimental data has failed to demonstrate that the levels of shaking of a 12-pound baby as in Garner had been demonstrated to be able to produce each of those findings as a primary mechanical result. That would something else has to do it.
So Dr. Stein, when they were discussing about whether it can be misdiagnosed, he said the findings here are so characteristic and the injury so immediately incapacitating that it is very, very unusual, if at all, to come to that conclusion without the findings, which sounds to me like he's saying, yes, you can diagnose it, but not here because because there was a retinal hemorrhage and there was brain injury.
Right.
No subdural.
Right.
I'm going to ask you about that in a minute.
Right, okay.
But he's saying, yeah, you can misdiagnose it, but not here because there's a retinal hemorrhage and there's brain injury.
And the first acknowledgement of a possible mimic was 2007.
So let me talk to you. So there's no subdural hematoma here, and you said that that is very unusual in these allegations of shaken baby syndrome.
Right.
That they have an allegation of shaken baby syndrome without a subdural hematoma. Because, and tell me if I'm wrong, because the typical presentation that they say brings them, and I say they, I mean child abuse pediatricians, the typical presentation that they say brings them to say this child was shaken is subdural hematoma, retinal hemorrhage, and brain injury. Those three things, right?
Correct. And if you look at it in terms of the clinical unfolding, the baby is brought in with some kind of.
Well, let me ask this, because what I'm getting at is you have three things that they say lead them down that road.
Right.
Take away subdural hematoma. Okay, so they say in this case there wasn't subdural hematoma. So would you agree that even under their own theory, this case raises some legitimate questions about whether it's shaking?
I would say that because I don't think I've ever encountered a case with shaking as the allegation without a subdural. Usually they come in, the first thing they do is CT scan and see the subdural, and then you bring the ophthalmologist in, and then you bring in and so that you bring up, and then you look at the eyes and you look at the brain injury. I've even the physician that I've heard.
But let me, I mean, what I'm getting at, just to kind of finish this line here, what I'm getting at is when you read the testimony, did Dr. Stein in any way acknowledge that the fact that there wasn't a subdural hematoma as raising a question about his conclusion that this was shaking?
I didn't see him questioning that. I think that the retinal hemorrhaging was probably his overwhelming thought.
Okay. Now, Dr. Stein also said that he died. He said this baby had global axonal injury, which he means is diffuse axonal injury. Okay, so first of all, what would he be? What did he mean by diffuse axonal injury?
Diffuse axonal injury occurs in mechanical trauma like impact and concussion. But if you look at as I visualize this, if every nerve cell in the brain has axon, which reaches out and touches this nerve over here. It has a dendrite, which reaches out and tingles with the nerve over there. And so diffuse axonal injury implies that in a brain injuring rotational acceleration, that the brain is being jostled such that you break the axons, diffuse, widespread. Injury to the axons that does not necessarily injure the nerve cell itself. So that it is the injury of concussion, but the demonstration of axonal injury is not obvious on imaging at all, and it is a kind of an autopsy finding. Actually, the early statement said that the retinal hemorrhaging and the subdural bleeding is a marker for the axonal injury that we presume is present.
But I guess that he is presuming it's there, but he has no way to know if it's there. Is that right?
That's correct. The radiologist reading it as hypoxic injury from lack of oxygen. The radiologist has not commented that he sees axonal injury. And then by the time of the autopsy, 8 months later, the brain has shriveled up to almost nothing. And so that whether there was started off as some kind of axonal injury, widespread edema, or injury from lack of oxygen, I don't see that the autopsy, after the brain has gone through 8 months of
Wait, no, the autopsy could not determine
No,
it,
no.
even if they wanted to,
Here they wanted,
because of the condition of the child at the time.
if the child were to die and have the brain sent off to autopsy at death in the first 24 hours, and it could be established that there was no hypoxic injury, but it's all mechanical, then under the microscope, I'm not a pathologist, but they might see the.
But the point is Dr. Cox was, Dr. Stein was telling the jury there's diffuse axonal injury when there was no way for him to know if that was correct or not.
That is my understanding. You might ask that to a pathologist, but there's no way that I don't think he could say that today.
Okay, so he said in his testimony, he said his findings that led him to the shaken baby theory were diffuse axonal injury and retinal hemorrhages. Okay,
Right.
So diffuse axonal injury, he has no way to know if that's really correct. And the retinal hemorrhages, we've discussed ad nauseum, that they are not connected necessarily to shaking. There's no way to say that the retinal hemorrhages were caused by shaking.
Correct.
Okay, so is it a fair statement that both of the things he relied upon in saying this was shaking were invalid?
Not been validated yet. Right, invalid.
Okay.
Right, invalid.
Okay. Now he was asked, Dr. Stein was asked about whether he was following protocol in his evaluation and determination that this was a shaking case. And what is your opinion as to whether he was following the protocol from 2004?
I think he was doing what the American Academy of Pediatrics, when the U.S. Department of Justice was saying in 2004. The diagnosis, don't exclude you. You don't have to differential anything. You've got this finding, this means this. So that we say protocol, now you get your differential, you deal with your exclusion, you do additional workup, you look for this kind of thing. But I don't, in terms of a protocol, I don't know if the hospital had a protocol.
But he certainly was following.
He was following the standard of the times.
Okay, so he was doing what he was expected to do at the time.
Right.
Okay. What would he do? Would he or any doctor do today handle this case the way Dr. Stein handled it in 2004?
Objection, that causes speculation on the part of the switch.
I'll
What a doctor would do today.
I'll rephrase that.
Stay. Go ahead.
To your knowledge, if a doctor today handled this case and called it shaken baby syndrome strictly upon the signs that Dr. Stein referred to, would he be acting in accordance with the current understanding in the medical field?
I don't think so. I think he'd be required to formulate an extensive differential diagnosis. He would be required, there would certainly been a quick move to MRI, MRV, technology that's now pretty standard. I'm not sure how standard it was in 2000. They would have done a more massive coagulopathy workup. They would have there would have been a lot of other studies done.
Since you mentioned looking at a differential diagnosis, just run us through, what does a differential diagnosis look like for a child presenting into the hospital with the conditions that this child had?
Child comes in looking like this, seizing, and not responsive. The first move would be to get a CT scan. As soon as you saw the CT scan with the brain edema, you would have been certainly trying to control the seizures, because uncontrolled seizures can be primary brain damaging, resulting in brain swelling. You would be looking to make sure there was no coagulopathy that needed treated. You would have proceeded quickly to an MRI, because you're looking for, that's the best test we have to actually define what's going on in the brain and to look for neck injury. And those would be kind of the first initial steps. You would be looking to rule out infection. That would be kind of lower on my list, but it's still on your differential. And mechanical trauma would be on your differential. Uncontrolled evidence for pre-existing issues would that could set up an unfolding, would all be on your differential.
So back then in 2004, he wouldn't have been expected to do all that.
No.
But today,
I would not be in the game then necessarily, but no, this was so clear. Once you have the guidelines from the academy that this had to be shaking in the absence of external evidence of impact, then I don't know how far he would have been expected to keep pursuing.
so he said, Dr. Stein told the jury that the combination of retinal hemorrhages and brain swelling, the words he used, were rather unique, which is why he said it was from shaking. It just
Unique, I guess, in terms of what he would see with what he thought a short fall with.
well, it sounds like, I mean, it sounds like he's saying he knew it was shaking because when you put those two things together, it's so unique, it can be nothing else.
Right.
Is that right?
That's what I read it, yes.
Okay. Is he wrong?
By the standard of the time, he would be in line. Now, I think he'd be very wrong.
Okay. Now, he also said that there was no evidence of impact in this case. Now, Ms. Gilbert obtained the CT scans in this case, correct?
Correct.
When you first looked at this case, the CT scans were unavailable. We didn't have them to give you to look at, right? And then just earlier this year, 2026, they became available and you had the opportunity to look at them.
Correct.
Okay. Now, the first CT scan, tell us about the first CT scan.
It's not available, number one. The radiologist read it as edema throughout the whole brain, not just one area, but swelling of the whole brain. And also hinted that there might be some hyperdensity at the right occipital tentorial area back over here. Didn't really call it solidly, but suggestion that it was there. And then also at the Children's Hospital, the neurosurgeon and the neurologist got to see the initial film and also questioned that there might be a little something going on back at the right occipital area. But that's the way the first hospital radiologist read the film. At the second hospital, they did the second CT scan about 4 p.m, which is what we do have. And this would be 30 hours or so after the door frame count and about 24 hours after the presentation. So you've got this kind of gap in there. And on that CT scan, the brain is even more swollen, is what the report says, more swollen. But I don't know if the radiologist just forgot to put the sentence in or forgot to dictate or didn't see it, but he didn't call any acute bleeding inside the head and the brain itself or mention anything inside the skull outside the brain itself. Which and it's just even as a non-radiologist, to look at a lot of these films, even when I look at that imaging,
Objection, Your Honor, he's outside of the scope of his professional skill and training. He's testifying as, in effect, as a radiologist.
Sustained.
Can I ask you, Ms. Gilbertson?
Mhm.
So, Dr. Glasnick, like I said, you're not a radiologist. Okay, you look at scans in your practice, right?
correct.
And is it true in the medical world, a lot of doctors who are not radiologists will look at scans and observe things, but then go to radiologists or neuroradiologists for a more informed opinion?
Oh, yes, and what I do is I look at the imaging myself, and if what I see matches what the report says, I'm very happy with the report. If I see something on this image that if I think I see something on the imaging, which has either not been mentioned or overlooked or not addressed by the radiologist of record, then my advice to the attorney is that you need to go out and get this independently reviewed by a radiologist to either confirm or refute what I think I am seeing. I think it actually would be unacceptable for a child abuse doctor to evaluate a case like this and not look at the imaging themselves. That would be, no, I don't, I'm a child abuse doctor. I look at all these cases, but I never look at the imaging and I never allow that imaging to inform my opinion at all. I think that would be grossly substandard. And so that again, I'm not signing off as a radiologist, but when I look at these images,
So,
the thing I told you was get these looked at.
well, so that's what I was going to ask you. You looked at the CT scans of this child from Texas Children's Hospital in Houston,
Correct.
right? And just describe to us what you saw.
Well, just as it been,
Objection, Your Honor.
Overruled. Go ahead.
just as the doctors had hinted, I'm seeing acute epidural hemorrhage in the right occipital area, which if that's validated, is not explained by the shaking hypothesis in any of its iterations. It is explained by impact. So I'm seeing what looks like epidural hemorrhage back in the right occipital area, and it appears to almost go into the right lambdoidal suture. So that's what I see there.
All right, I know you ruled. I'll renew my objection. He's providing testimony tantamount to what a radiologist would provide.
I think all doctors look at, overruled. Go ahead.
So I'm sorry, finish your description of what you saw.
What I saw is, to me, suggested epidural hemorrhage, which is just a little, you start with the scalp, you start with the skull. On the inside of the skull, you have the dura, thick membrane with a good vascular spot fairly firmly attached to the skull. And you have a membrane called the arachnoid, and subdural bleeding is between the dura and the arachnoid. Then you have the subarachnoid between the arachnoid and the brain. Epidural hemorrhage is between the skull itself and the dura. So you have epidural hemorrhage here, you have subdural hemorrhage here, and you have subarachnoid hemorrhage here. And epidural hemorrhage is evidence of impact. It is not explained by the shaking hypothesis in any shape or form that I have ever encountered. The shaking hypothesis is talking about torn bridging veins and subdural bleeding, or possibly subarachnoid bleeding, but it is not accounting for impact. So to me, this finding, if confirmed by radiology, would serve to confirm even if there was nothing external, no bruising on the outside, but given its location back here and the defendant's account of coming out with the baby looking up hitting, that would be exactly where the baby hit.
Okay, let me ask you to describe from reading the trial testimony and understanding what the facts were that were presented. What did Mr. Gardner say happened where he hit the baby's head?
The baby's, as I envisioned it, he was carrying the baby in his left arm. That's pretty standard. The body would be through here. The baby's butt would be down here in the hand. The baby's head would be kind of hanging over the elbow, beyond the elbow. That's what came through the
Objection,
testimony.
now, this is all spec. He has no idea of the manner and the means in which this defendant was carrying Kaylin Garner that day.
Your Honor, he's talking about the testimony from the
Well,
trial.
it did not, the testimony, as I recall it, did not go into that kind of specifics, Judge. It's a speculative on part of this.
I don't
witness.
recall it being that specific, and if you need me to look back.
Well, that's I'll ask a different question, Judge.
Okay,
Just to be clear in the record, Mr. Garner said he hit the baby's head on the door, right?
Correct. It's in the record.
Okay, we don't
Witness
worry.
that boundary.
I'm not gonna worry about what's in the record.
Okay.
What's in there is in there. But that's when you say you saw evidence of impact. The epidural hemorrhage was evidence of impact on the baby's head. Is that right? And is that consistent with the baby's head being hit on this door jamb?
That would be impact, and it would be starting at the back of the head area, which is where this was seen.
And what you were seeing on the CTs, in my understanding, that that was actually referred to in some way earlier by other doctors that had looked at this in the records.
The reader of the first CT scan said, some hyperdensity in the, I got the report, but it's in the white area, probably given the hyperdensity of the brain may or may not be real. The neurosurgeon and the neurologist at Children's Hospital, they're going to look at the films themselves. That's standard of care. Look at it and questioning some acute blood back in this area as well. The remarkable thing is that the radiologist reading that film made no mention of it. Either he forgot to dictate it, wasn't thinking what he did, but there's not any mention of any blood between the skull and the brain of this baby. When the neurosurgeon and the neurologist have questioned it being there, and the reader of the first CT scan also questioned that it was there. So that I don't know how he overlooked it. But I've got his report, and it's not.
But I mean, the point is that the radiologist at Texas Children's overlooked it or didn't put it in his report.
Correct.
Okay, and so then Dr. Stein didn't acknowledge it or know anything about it in his testimony.
No.
Is that right?
Correct.
Okay, so Dr. Stein, in his position, is he appropriately relying upon the radiologist to give him this information?
I think he could chose to rely on him. Yes, he's relying on information to give him insight into what that imaging shows. The fact that whether he looked at the imaging himself, or what he saw if he did look, or whether he just went with the report, I can't answer for Dr. Stein.
But the point is, in his testimony, he appeared to know nothing about this.
I saw no mention of it in the testimony.
Okay, now, when you saw this, you freely and openly told us this is what you saw, but we needed a radiologist or a neuroradiologist to really look at this and to confirm it.
Yes.
Right. And you understand from really staying in contact primarily with Miss Gilbert that she was making a tremendous effort at that point to find a radiologist or neuroradiologist that had time to get involved and look at this.
That's
right?
correct. It's all unfolded over the last 7 8 weeks.
Right. So eventually she was able to make contact with Dr. Dale Vaslow. Is that your
Correct.
understanding? Now, who is Dr. Dale Vaslow?
He's a neuroradiologist in Missouri. He reads his films. He's published in the area of chronic subdurals. He's published in the area of intracranial venous thrombosis. And so he seemed like a very appropriate person.
And so Dr. Vaslow, he was able to look at it for us, okay? And you understand that he looked at it and he reached some conclusions about it himself.
Correct.
Now, in the medical world, in reaching conclusions, do doctors consult with doctors of other subspecialties?
Oh, yeah, absolutely, yes.
And a pediatrician like you would consult with a neuroradiologist like Dr. Vaslow.
Correct.
And then Dr. Vaslow would give you information that would help you reach a conclusion or a diagnosis.
That's correct.
And so did you take the information that Dr. Vaslow came up with after looking at these scans and evaluating this? Were you able to take that information and consider it as part of your determination about what really happened to this child?
Yes, that's what I'm supposed to do. The child abuse doctor is supposed to reach out to consultants to help form an opinion. I, as a reviewer of a record, perspective, I have a duty, I think, to look out and appropriately consult with neurosurgery, neurology, radiology.
So having done that in consultation with Dr. Vaslow, who was an expert in this,
Right.
were you able to put all that together and reach a conclusion about what happened to this child?
In my opinion, yes.
And tell us what that conclusion is.
My conclusion is, or my push, again, my role is to look for a plausible alternative that was not excluded in this case. And when I look at this case, and I look at the imaging, and I start questioning epidural hemorrhage and venous thrombosis inside the child's head. That's what I was questioning, and that's what Dr. Vaslow was confirming. In that intracranial venous thrombosis as a medical entity is more common in infants. It's a period of high probability. It's a rare problem, but it's a high probability. It is recognized in the literature that I was familiar with from about 2011 that it can be set off by a minor trauma. We're not talking about having to be a brain injuring trauma. We're not talking about a primary brain insult at the moment of hitting that door frame. But if hitting that door frame were adequate to jar the bones, the dura, and the lambdoid suture back here to the point of causing epidural bleeding, it was more than a trivial impact. And that in that area, anatomically, I could show you anatomy from medical school type of thing, runs the transverse sinus. Now, what a sinus is that blood comes into the brain from the bottom of the skull with 4 arteries. These then nourish the brain itself and supply oxygen to it. And then the blood is collected into the cortical veins and directed either up to the superior sagittal sinus and the transverse sinus. Now, sinus is, they say, is a different word than vein, but it is a huge, large volume vascular venous channel. It's generally in the shape of a triangle as opposed to a circle. That kind of keeps it open and from collapsing. And the superior sagittal sinus starts in the middle of your forehead, under this area under the skull, goes across the top of the head, comes to the back, and then bifurcates into the right transverse sinus and the left transverse sinus. And then it comes around and then dumps the blood to the jugular veins. So all the blood comes into this area through the arteries, nourishes the brain, and gets collected into this big structures, and into it you have the blood from the brain feeding into this structure, coming over the back, and you have the transverse sinuses and going down. Now, the importance of this is that I'm an old dude, and I'm worried about my heart attack or my arterial stroke, where an artery to a portion of my brain blocks and I have stroke. That's what we think of. But there's also an entity called a venous infarction, where if a vein or venous structure draining the brain blocks, it's like if the drainage ditch in front of your house is blocked and Beaumont gets a 10-inch rain, water backs up stagnant in your yard. So that if the venous drainage system blocks with a clot, then blood flow from the brain cannot proceed. Blood flow bringing oxygen to the brain is then shut down or compromised. That's hypoxic ischemic injury. That is what was being read on the imaging. And when you have hypoxic ischemic injury to the brain swells. So when I look at that imaging, following guidelines from Headland and he's authored a consensus statement, that and apply what I see as directed by Kerry Headland, I'm seeing evidence of clot in the superior sagittal sinus and the right transverse sinus, which so you can have a head impact, not horrible. The baby could have had no brain injury, could actually have cried, settled down, taken a bottle, gone to sleep, and then in the interim, this whole structure clot. And when that happens, the brain is then not getting oxygen. You have your hypoxic ischemic injury. Without oxygen, the brain swells because it can't maintain the water, keep water out. And then the onset of that, classically is described as, and symptoms can be subtle, classically seizures. And then that's what was described in the chart at about 3 o'clock. So then you have a primary event, not brain injury, but you have evidence of injury through the structures out of the skull and around the brain. And you have imaging evidence of a complication, a secondary complication of this event. And that complication is recognized to result in hypoxic ischemic stroke with brain swelling, with a seizure presentation, with increased pressure inside the head, which was documented in the ER with a bulging fontanelle. And the literature clearly establishes that can account for extensive retinal hemorrhaging. So that as I look at this case, I'm seeing a history that came through the chart, matched with objective findings, which coupled with published literature can account for all the findings at TCH and the leading to, well, the autopsy is so far down the line, it doesn't count that much. So as I look at this, I'm saying that I perceive, or I think I'm seeing a plausible alternative to abusive injury that can fully account for the findings in this case, which is what my usual role is. And I balance that against the allegation in this case. And that given the evolution of our understanding of abusive shaking, and specifically given the absence of any demonstrated neck injury, which there's not only what you find, but what you don't find, but in the absence of any demonstrated neck injury, and in the absence of any acute rib fracturing, if you took and grabbed the baby's chest and did this, I would expect rib fracture. So in the absence of findings supporting shaking, given the evolution of our understanding of the shaking allegation since 2000, coupled with what I perceive, read as a mimic set off by impact, by trauma. I'm not saying, but set in motion, and a finding which is there on imaging. I'm seeing what I would call a plausible alternative, matching it better than the allegation, and for the consensus statement that the diagnosis is not made until all plausible alternatives have been excluded. And at this point, given the first CT is missing, but the second CT is there, that the epidural hemorrhage and the venous sinus thrombosis is there. I don't see any way that one could exclude the alternative that I am saying that I think I see, from the differential. And that means that I don't see that the diagnosis of abusive head trauma, based on the findings that I see, can be sustained. There are no other fractures, there's no other bruising, there's no other findings in the rest of the body to shore up a diagnosis.
So, Dr. Stein, for whatever reason, didn't know that this was in the CT.
He didn't mention a word about it.
So if he had known, what would you have expected him to do?
I think if he would have phoned and said, hey, this kid's got epidural bleeding in the right occipita, didn't that usually impact? I would think that might have jarred a few thoughts. I think that hey, that blood sitting back there right next to the transverse sinus. Maybe we ought to do a contrast enhanced venogram to see if things are open or not open. Because certainly the literature I'm familiar with was the American Heart Association 2009 and the 2011 Kronikowski and the Hedlund 2013, which is all after the fact, but that's what I rely on. I don't know what he might have had at his fingertips in 2000, but clearly by 2011, 2013, this was a potential issue on the table.
So Dr. Stein said there was no evidence of an impact of this baby's head against a hard object.
That's what he said, yeah.
Okay. Is he wrong about that?
I think external evidence, there was no evidence of that. I think the CT scan is clearly evidence of that.
Okay, so he just missed it.
Well, Dr. Stein
or somebody.
The radiologist didn't call it. If Dr. Stein had been told this child has epidural hemorrhage back at the right occipital area, Dr. Stein, I would think, would have started to think along the lines of impact.
So is it a fair statement that Dr. Stein seems to have made a quick decision that this was a shaking case and didn't really consider anything else?
That I think could be fair to say. I think I can't speak for Dr. Stein, but I think as soon as he saw the retinal hemorrhaging, he would have reacted that it's a shaking case, and he would have denied evidence of impact because he saw no bruising, no swelling, and unless he went into the radiologist and says, "Hey, look at this. I'm not seeing why didn't you call this?" and start the chain of investigation, he would have just proceeded like he proceeded.
And Dr. Stein at one point said that the combination of the retinal hemorrhages and the brain swelling were so unusual and conclusive that if it wasn't shaking, it would make medical history. What do you have any comments about that?
Well, I think that maybe if it was coming forward today, we'd publish the case, but clearly the literature recognizes extensive retinal hemorrhages in venous sinus thrombosis. It recognizes brain swelling. It recognizes onset of seizures. It actually recognizes a delayed onset up to 2 weeks after a minor trauma can set this ball in motion. In this case, of course, we're only speculating maybe 6 to 8 hours from the time of the reported accidental door frame impact until things were going off the rails about 2 or 3 in the afternoon.
Now, he said, Dr. Stein, excuse me, said that in his opinion, to a reasonable degree of medical certainty, this child, Kaylin Garner, suffered from shaken baby syndrome. So what does it mean to say something to a reasonable degree of medical certainty?
I have a hard time defining that, but he means it's beyond probability. He thinks it's about as definitive as he can get.
So do you recall that in one of the AAP guidance documents, they told doctors dealing with abusive head trauma that they're not making a determination beyond a reasonable doubt, that their determination is something less. Do you recall that?
Objection, that's a mischaracterization. He didn't make a determination beyond a reasonable doubt. It was beyond a medical certainty, Judge.
That's exactly what I'm saying, Judge.
No, he said beyond a reasonable
You
doubt.
said doubt. The second time you said doubt.
Yeah.
So do you recall that from the document? If you don't, you
I don't
don't.
recall, I know it's in some of they talk about reasonable doubt. Not as, it's not beyond all doubt, there's reasonable doubt, but I don't go
Hold
there.
on, hold on. I think we're still talking about two different things. The question had to do with the medical beyond a reasonable medical
I'm
certainty.
gonna move on.
Okay.
If it's okay.
So let me know where you are
I'm
on.
getting ready to shift gears, right?
So that's probably a good time to stop. I was trying to wait till we got through Stein, I think. Okay, so let's go ahead and break for lunch. It's about 12:30. Let's get started at 1:45. And so if you guys need me, I'll obviously be around, but we'll be in recess until 1:45. All right, we're back on the record. Looks like everyone is present, state's present applicant, Mr. Garner, Mr. Udishin, you may proceed.
Thank you, Your Honor. I would first, look how I approach the witness.
Of course.
Dr. Glasnick, I want to show you what we've marked for Defendant's Exhibit 9 and Defendant's Exhibit 10. Without saying anything about them, do you recognize those?
Yes, I do.
Okay. And let me show this.
Did you call them defendants?
That's how they're marked. What are we calling our exhibits?
Kids, they don't make.
Where did these?
Oh, they don't make an applicant
Applicant.
sticker.
That I found.
I can get stuff I need to.
All of these have defendants on it. So what we'll do now is just for the record to be clear that all of the previously admitted exhibits, which was 1 through 8, are titled defendants, and those are applicants. And so we'll just use the defendants, keep it the same, knowing that defendants equals applicants.
These pursuant to your subpoena.
Okay. This is his question.
Pursuant to the court orders from, correct.
So this wasn't a part of the state's record at trial?
No, it was not.
Twofold objection, Judge. I think I know where you're gonna rule on the first one, which is, my running objection, that this was a part of the underlying court record. The second objection is that this is not the appropriate sponsoring witness for these CAT scans from the Texas Children's Hospital, particularly if they weren't, again, a part of the underlying, admitted at the underlying trial.
Is this an authentication issue you're bringing up
Your Honor,
or something?
these, if I could address that.
Sure.
it's that these are the CAT scans that Dr. Glasnick testified about before the lunch break.
But
And they're already, I believe they've already been introduced and accepted as evidence as part of a bigger exhibit, but I'm just pulling out these 2 pages so the court can look at.
would that be number 3, the imaging files from Texas Children's Hospital?
Yes, Your Honor.
And had I known, I would have lodged my objection at that time, Judge.
Well, I mean, the imaging files from Texas Children's.
These are different.
No,
These are-
no, I'm sorry, these come from that. These are in that exhibit.
That's correct.
Am I right?
They're in that exhibit, but they weren't admitted in the underlying trial. It was obtained subsequently through their, the court order, as
Okay.
additional records.
8 and 9 are admitted. That's overruled.
Okay, so, can I proceed here?
Yes, sir.
Dr. Glasnick, I'll hand you again, defendants, 8 and 9. First of all, are those the scans you were referring to earlier in your testimony?
Yes, this is the scan. It says up in the upper right, Garner, Kalen, date of birth 12/3, Texas Children's Hospital, date of 2/26/2000 at 4:02 p.m. in the afternoon. And at the upper right corner, you see sequence 2, image 14 of 23, and sequence 3, image 13 of 23.
So you were talking earlier about a right occipital hemorrhage.
Correct.
And I would just like for you to hold them up and show, hopefully the judge can see it from there. But just point to what you're looking at and then I'll hand it up, then I can hand it.
You're welcome to use the Elmo and we can switch the TVs where we all are seeing what you're
Okay.
talking about.
Can you figure out?
If you, yeah, so if you switch
Put it under here.
on the Elmo machine itself, Mr. Coleman, would you show where the input button is, please?
Yes, Judge.
Yeah.
Which this right here is something, having Mr. Coleman show how to use the electronics.
Sure, he knows more than me.
He's come a long way.
Why do everybody keep saying?
Because you've come so far, I'm giving you props. Giving you some kudos. There it is.
Thank you.
And I also have that on my screen here.
Okay,
So-
put number 9 up first and we'll let.
And there's a pointer with the green. Let's go.
Okay, oh, great.
Very, zoom it out.
Yes, you should be able to.
There, that's. Okay, so Dr. Glasnick, can you explain to us what we're looking at here?
Yes, this is a CT scan. It's X-ray technology, means you're using X-ray beam. So the baby is on the table with its feet towards you facing up. So 9 o'clock is the patient's right, 3 o'clock is the patient's left. On CT scan, bone is white, brain is gray, water is black, and acute blood is whiter than brain. So this is the right posterior occipital area, and that blood is sitting right there. And notice how it kind of almost like mounds into the brain. That makes it epidural as opposed to subdural blood. And this little spot right there is the lambdoidal suture. That's the normal. Babies are born with the various skull plates separated by the sutures, and so that looks like this blood, if you look real close, almost seems to track itself down in between those. And I'm not doing very well with my pointer.
And if it's easier, you can do it right behind you.
Oh, okay. Oh,
You can look over there.
yeah, this is the brain itself, and normally you would see sort of arachnoid space with water about 3 millimeters thick, but the brain is so swollen that has all been squished out. You come down here, and this is this mass of epidural blood, and it almost seems to separate the two bones right there. This is was not mentioned. I mean, I just overlooked it or forgot to fill the sentence, or the transcriber didn't put it in. But this is clearly here to the right occipital area, and that would be confirming impact to this area, not necessarily a trivial impact to the area.
Okay, and let's show.
Oh, but I put the brain. Normally the brain is not this dark. When a brain is not getting enough oxygen, a lot of your energy is involved in keeping water out of the cell. So if you run out of oxygen, water comes in, and water on CT is dark. So this brain here is much darker than it's supposed to be, but this is massive brain edema with this acute blood, epidural blood sitting right there and looking like it goes in between those two bones right there.
Okay, let's show Defendant's Exhibit 10.
And again, see,
So first of all, so is this is not the exact same scan as before, but it's the same
no,
thing. To
What's
explain
neat-
the difference.
Well, CT does, they're really neat. They put you in this machine and they start shooting X-rays at you from all different angles. And then they just like bologna slices going up. And then they push a button on the machine that flies it like in the sagittal section. And then they can do front to back. So what you're looking at is like a bologna slice. And these slices are I guess is about 5 millimeters. What am I saying? Each slice is 5 millimeters in thickness, so your slice of bologna is 5 millimeters thick. And this is where that you see the date and the time over here. And this is sequence 2, image 14 of 23. So you could ask a radiologist, will you please pull up sequence 2, image 14 of 23, and this image would appear.
And it's the same blood, but it looks a little different.
Oh, yes, because the other one was slice 13. So this is the bologna slice next to it. So that blood is now not seen here, but you see this again, mound of acute blood right over, this is the other side, but this is clearly different, and it's wider than brain. It's not fluid, it is clotted blood up to about, could be up to 10 days old. Obviously, the history implies that it's would not be that old, but the aging of acute blood on a CT scan, if it's wider than brain, it can be 1 to 7 to 10 days old.
Okay, so in this case, I'm gonna move on from these scans.
Right.
In this case, they didn't do an MRI, I think.
Correct.
So do you know why not?
Well, MRI, you got to have sedated. It takes about 30-40 minutes. CT scan takes a matter of a few minutes on a terribly sick infant. It may be a bigger deal to do an MRI. Back in 2000, I don't know what the standard was. Certainly by 2010, 2011, MRI, early MRI would be pretty standard.
So today they would do an
Yeah,
MRI.
yeah, I think so.
Okay. Now, there was some testimony from Dr. Stein where he was describing to the jury what the shaking was like, and he gave an example of a tomato in a can. Do you have some comments about that example he gave?
Yes, I think that was an inappropriate example to use, because if you had an egg or a tomato in a glass jar, without surrounded by water, you shake it, it's going to bounce all over the place, crush, which is what the jury perceived he was demonstrating by that. But if you took that same jar, totally filled it full of water, and then put the tomato in it, so there's no air in that jar. In other words, much like the intracranial vault, where the brain is surrounded by water, not surrounded by air, and repeated shaking, the brain would not be bouncing off the side, it would not be bouncing around.
So today, do genetic factors or testing for genetic factors have anything to do with these types of evaluations?
Yes, particularly if the issue of you're always screening for easy bleeding, like hemophilia, factor 12, factor 9, and platelet disorders, or people who bleed too easily. But everything in the biological system is kind of like a bell-shaped curve. And you also have the people who clot too easily. That's called thrombophilia, clot loving. And there is a genetic workup. You can be genetically predisposed to easy clotting. These can be people who, young women on birth control pills, have a stroke, or someone who sits on a plane without getting up and walking around for 4 hours can have a clot in their leg, which can break loose. So this is the thrombophilia. So in any case where a venous thrombosis is an issue, there is a standard workup of protein C, protein S, factor 5, Leiden, I think it's Leiden, I don't know for sure, but there's a series of genetic tests that are done to make sure that individual is not specifically prone to clot.
And they didn't do those back
No.
in 2004. Okay, now in Dr. Stein's testimony, he was asked a question by the defense attorney, and the question was, and in this case, obviously it was a right occipital hemorrhage, correct? And his answer was it was not a right occipital hemorrhage. Now, what you're showing us on these scans, is that a right occipital hemorrhage?
Yes, it is. It's epidural as opposed to subdural, but it is acute hemorrhage in the right occipital area.
Okay, so when he says it wasn't that, he's just wrong.
I think he's wrong or didn't understand I don't know if he looked at the imaging himself or not.
Okay. Now, I want to shift gears and talk about Dr. Patricia Moore, the state's other medical witness. And you understand Dr. Moore was at the Harris County Medical Examiner's office and did the autopsy, I don't know, 8 months later or so. And so she had, I guess it's fair to say, less information to provide the jury than Dr. Stein did.
Yeah, she would have much less information to provide.
But nevertheless, Dr. Moore testified that these injuries were caused by shaking. You recall that was her testimony, and that she also testified that the only other thing that could cause these injuries besides shaking was a severe motor vehicle accident.
Right.
Okay, now I think you've already told us, but that testimony is incorrect.
Yes, that test was incorrect. What she would have had at her disposal 8 months later would be that the brain had shriveled up to the point of about 1/3 its original size, and all that would show would be a terribly damaged, shriveled up brain. So from my background, there would be nothing on that to allow her to say what would happen 2 hours before, 1 hour before, 3 hours after presentation. But what she did have was when they sliced open the eyeballs and looked, there was residual of the of staining where the retinal hemorrhages were. So she would have had, and the testimony I thought I read was evidence of retinal hemorrhaging, which in the thought of the time would be that this is evidence of residual evidence of retinal hemorrhaging, and that would require a requisite component of shaking.
But so even though we now know that's incorrect, at the time in 2004, she was giving testimony consistent with what was believed to be correct.
Correct, and I now have to, there was comment about the staining in the eye, which is, I assume, I have to say that's what she was basing her opinion on there. But the brain would be so damaged and scarred at that point in time. I don't know that one could make much of a comment as to what the original event was. The x-rays were read, of course, as hypoxic ischemic injury without enough oxygen getting to the brain.
So you're aware that Dr. Moore, at the time that this writ application was filed, she recanted her testimony where she signed an affidavit saying that she would not testify the same way now based upon what her understanding is of the new science.
I've heard that, Tristan.
Okay, so she's not the only doctor that's given testimony in the past that supports some of the theories of shaken baby syndrome that has later decided they were wrong. I mean, that happens fairly frequently, doesn't it?
Not infrequently, and I think that many, I never testified for the prosecution, but I have colleagues who were testifying that shaking is real, testified for the prosecution, who then have now totally done an about face. Dr. Plunkett said he would volunteer to review any case he had previously said otherwise, to on any kind of appeal. So that, yeah, once you realize that things have changed, the ethical thing to do is to admit it and try to not make the same mistake again.
Well, so that's really my final question is just as an expert witness, as a medical professional, as somebody who testifies in court, what are you supposed to do when you realize that your testimony was wrong, because the science has changed or for some other reason? What should you do under those circumstances?
I don't know that I've seen it in writing, but I would think she should be willing to go back and volunteer to be involved in the revisiting of the case. You know, there may be other evidence, but if what your testimony implied is no longer adequate, it would seem appropriate to inform attorneys that a revisiting of the case might be appropriate.
Okay, thank you. I'll pass the witness, Sharon.
Thank you, Mr. Houston. Would you hand me those two, and I'll keep them with this, if anybody
I'll
needs.
switch. Yeah, that was my plan, just.